Office of the Australian Information Commission before us. Is Tid? Is it Tid? You have provided your opening statement to the committee beforehand, so before I ask you to read that, I'll indicate the committee is happy to accept that and table that. Please proceed.
Chair, I appreciate the opportunity to provide a brief opening statement to the committee on behalf of my colleagues, the Privacy Commissioner, Carly Kind, and the Freedom of Information Commissioner, Alice Lineker. Commissioner's clear commitment to targeted regulatory priorities are impacting both the marketplace and the government sector to elevate information rights for the Australian community. We still have work to do, but our regulatory impact is demonstrated by the contribution of the OIC to the Commonwealth integrity landscape with the incorporation of metrics to achieve outcome 3, transparency and accountability of actions, and decisions are improved. These measures include the percentage of Freedom of Information Act requests finalised within statutory timeframes over a quarterly period, Australia's right to information rating, and importantly the percentage of OIC reviews of FOI decisions and FOI complaints that were finalised within a financial year period. In that regard, I'm pleased to report on the significant improvements in case management as we refine our approaches, including finalisation rates and the age profile of complaints and reviews. 80% of our FOI reviews are now finalised within 12 months, notwithstanding a 55% increase in applications against the same period last year. And the case age profile has reduced to 8.1 months. Similarly, the average time to resolve FOI complaints has reduced to 2.3 months. These outcomes are the lowest in the last 4 years. In privacy, notwithstanding a 72% increase in case volumes to February 26, we have finalised 34% more than the same period last year. The average time to finalise a complaint is 5.9 months. This is also the lowest recorded age finalisation timeframe in the last 4 years. It's important to reflect on what this data tells us beyond the positive demonstration of our process improvements and regulatory effectiveness. These significant and sustained increases in applications and complaints tell us that community concern regarding their information rights is growing at an unprecedented level. This is borne out in our community attitude surveys. Community engagement with the OIC is demonstrated by a significant increase in contacts. We are prioritising our efforts to ensure that both the community, government and industry have guidance to better support their compliance and promote prevention and early resolution. As a regulator, our posture is proactive to promote higher levels of compliance by regulated entities and, importantly, ease of compliance. In doing so, we anticipate benefits to the community through better operationalisation of their rights. For industry and government, our objective is a more seamless and cost-effective approach to compliance. For government in particular, we're focused on greater workability as staff operationalise both the privacy and FOI regimes. We are advancing new approaches in consultation with agencies to address historical issues such as volumes. 75% of FOI applications to agencies are for personal information. The FOI Act provides opportunities to release personal information effectively, efficiently, and we still preserve the right to receive a timely notice of decision. We're exploring all opportunities to inject our expertise to maximise the opportunities provided under the statutes to ensure ease of access, compliance with the workability of government. Our proactive approach to regulatory interventions has also seen us deliver an increase in the publication of effective regulatory guidance, including reports to address new and emerging harms. These include guidance on practices like screen scraping, the use of automated decision-making and training AI. Our view to compliance is equally proactive, with an historic privacy sweep to engage and further work in 2026 to test regulated entities' settings. Under the 3-Commissioner model and through the commitment of the OIC staff, our collective efforts demonstrate our impact are highly credible. The rights we promote and protect contribute directly to a healthy democratic system of government that serves us all. We are actively advancing efforts to maximise the opportunities available to us under these statutory regimes to ensure that they operate effectively for the community, industry and government. Thank you, Chair.
Thank you very much. We'll proceed to questions, but before I do that, I want to, remiss of me not to welcome the Honourable Senator Nita Green, representing the Attorney-General.
Thanks,
Thank you very much. Senator Black.
Thank you very much, Chair, and thank you for that comprehensive opening statement. I just want to have a look at, I guess, your role in the regulation of AI and what measures the OAIC has implemented to promote responsible use of AI across government.
Thank you, Senator. If I commence with a high-level overview and then in particular call on my colleague, the Privacy Commissioner, to speak to some of the guidance that she has recently instituted. The OIC is engaging with government in particular to support their understanding of the preservation of rights in the use of AI, and we're actively engaged in that regard as the regulator. In terms of community engagement, we are also ensuring that there is information available both to industry and the community around the preservation of rights, and in particular the Privacy Commissioner has published guidance relevant to this topic, and I'll turn to her to assist. Thank you.
Thank you, Senator. Carly Kine, Privacy Commissioner. The OAIC released guidance in October 2024, two sets of guidance relating to AI. The first is with respect to the use of commercially available AI tools, and the second is with respect to the development and training of AI models. Both pieces of guidance were primarily directed at organisations rather than government agencies, but certainly have applicable learnings for agencies. And in the interim, we've engaged extensively with government agencies, both in terms of receiving some complaints with respect to AI usage, with respect to receiving notifications of potential data breaches involving AI tools, and also in the policy space as well.
Excellent, thank you. And I guess just building on that, there are AI tools like Clearview AI that can't be used in Australia by agencies. Are you working closely with them to look at how you can balance that privacy aspect, the legislative frameworks that we have here? And are you, I guess, making recommendations one way or the other whether those types of tools should be made available?
I might unpick a few different things in your question there, if you don't mind, Senator. With respect to Clearview AI specifically, we historically have undertaken two separate initiatives. One was an investigation of the Clearview AI system itself and its training on images of the Australian community, and we issued a determination with respect to that, which found that Clearview AI itself had contravened the Privacy Act in developing its tool. And I can speak further to the outcomes of that determination if useful. We separately investigated the use by the AFP of Clearview AI at the same time, and this is back in 2023. And we found that the AFP had not conducted a privacy impact assessment before deploying that tool, as they are required to under a code under the Privacy Act that specifically regulates government agencies' compliance with the Privacy Act. And so we made a constrained or limited finding about the AFP's failure to undertake a privacy impact assessment before using Clearview AI. We haven't, to be very clear, we haven't banned the use of any product, including Clearview AI, in Australia. And the status with respect to government agencies' use of that product is that they're required to undertake a privacy impact assessment before using any high privacy impact technology, and that would extend to tools such as Clearview AI. We have also made a finding about the lawfulness of Clearview AI that's separate from what we've said directly to government agencies. I suppose to then zoom out to your larger question about the extent to which we're engaging with agencies and their use of a range of commercially available tools. We don't regularly provide advice to agencies in that respect. We're the regulator, and we expect their compliance with the Act and with the agency's code as well, which, as I said, requires a PIA before using those tools. And we don't have a role per se in reviewing those PIAs before agencies adopt AI tools.
Is it fair to say that any PIA that those agencies undertake, that something like Clearview would fail, and so under your own policy settings and them following those guidelines, they would naturally be ruled out?
I wouldn't put it that highly, but certainly in a context in which we've found that a tool such as Clearview AI is trained on data that was either unlawfully or unfairly obtained from the Australian community, and therefore made a finding against the company itself. That should absolutely, I would have thought, be a persuasive factor in agencies' consideration of the use of that
because
tool.
They can't get around the fact that it would contravene the Privacy Act here as it stands. Is that... don't let me put words in your mouth. I guess I'm just...
I wouldn't put it that highly. Again, our finding was a determination, which is an administrative decision about the specific technology at that point in time. It was then subject to a review in the Administrative Review Tribunal, which was never completed because Clearview AI withdrew from proceedings.
Okay.
And so the situation is not perhaps as clear-cut as it might be. I would say more broadly, Clearview AI has been subject to multiple pieces of litigation in multiple jurisdictions, has had findings against them by multiple regulators around the world as to the lawfulness and fairness of their tools. And I think there's very serious questions about the ethical nature of the technology, if not the legal nature of the technology. So there's a serious cloud hanging over that entity, as it were. Yeah. And I would have thought that that's a relevant consideration for any agencies considering using the technology.
And I guess for those agencies, though, when they're dealing with things like a 41% increase in child sex online offences just in Australia in the last 12 months, they want all the tools in the toolkit. So is there any, I guess, would you be looking at any future determinations balancing that, I guess, safety aspect of the community versus those privacy without infringing on people's right to privacy?
The Privacy Act sets up a regime in which it accommodates factors such as the need to protect safety and to balance that against the protections in the Act. It also accommodates where certain uses and disclosures of personal information are authorised or required by law. So I think there's quite a robust regime within the confines of the Privacy Act to allow for a range of different tools and technologies to be used, particularly in the security sector.
Okay. And I guess from your perspective, I guess as the watchdog's probably the wrong word, but agency, if our agencies are then using overseas countries and other jurisdictions to assist them with their investigations here in Australia, would that warrant the same breach? So would they be lawful investigations then?
Oh, it'd be very difficult for me to speculate, Senator, on the specific facts that you're talking about.
Okay. Thank you.
Thank you, Senator Blyth. Senator Cox.
Thank you very much, Chair. Thank you, Commissioners. The Privacy and Other Legislation Amendment Act of 2024 mandated that the OAIC to develop an online children's privacy code by the 10th of December this year. Can the Privacy Commissioner, Ms Kind, can you please provide an update to the committee on the development process and the timeline?
Thank you, Senator Cox, and thank you for your continued interest in this particular mandate of work. It's of high importance to us as an agency. Since we appeared here in December, the primary focus of our work in the intervening period of time has been drafting the code in collaboration with a drafter from AGS. That work is almost complete, and we are expecting to publish the draft code for consultation in mid to late March this year. And that will be accompanied by a 60-day consultation period in which we will consult with children, young people, parents, as well as industry and agencies. I will also be consulting with the National Children's Commissioner and the eSafety Commissioner as required by the legislation, and that will then advance us towards finalising the code by the end of the year.
That's great. Thank you very much, Commissioner, for that update. Can you maybe explain to us how the Children's Online Privacy Code intersects with the social media ban?
Whereas the social media minimum age regime excludes children from certain parts of the internet, the Children's Online Privacy Code aims to make the other parts of the internet safe for children, and in particular to ensure that the collection, use and disclosure of children's personal information is held to a standard that's, I think, befitting of the vulnerability that children experience in online realms, and that the best interests of the child are really centred in all considerations about designing and deploying digital services for children. So from how much data on children is collected, how they might be subject to things like nudge techniques to increase the likelihood that they hand over their personal information, specific categories of information like location data, which we know is more concerning and of greater risk for children. All of those kinds of issues will be addressed by the code.
Great. As a mum, I'm very glad to hear that, of two preteen daughters. And the Let me start again. The OAIC has taken an important child-based approach to consulting directly with children and young people, which I know you outlined to us at previous estimates. Can you now explain to us why this approach is so important and what insights have emerged from the consultations that you've outlined previously?
Thank you, Senator. We very much take a human rights-based approach to the work that we're doing, which holds that children have a right to have a say in things that concern them. And so that's why we've really centred children's consultation in the development of the code. We've done that by developing child-friendly materials, including for specific age groups from years 3 to 6, years 6 to 8, etc., so that we're really making sure that we're targeting children in a way that they can hear and understand. And we're going to be taking that forward into the next stage of consultation, where working with partners, we're developing a child-friendly version of the draft code so that they can understand what is proposed in the draft and then provide feedback on that as well. So we're really hoping that we'll get substantive input from them. I think I gave you some of the insights we've gained from them so far at the last estimates, but certainly we hear from children that things like location tracking in particular is something of concern to them, that they feel like they want more control over their personal information. And we consistently hear from children that they would like a right to have their data erased or deleted on demand, so that they can start with a clean slate, as it were. And that's an issue that comes up time and time again.
That's great. Thank you, Commissioner. What are some of the key issues that have arisen in the development of the code that are specific to our tech industry stakeholders?
I suppose... And noting that we've only done a more informal consultation with industry to date, and as I said, the statutory consultation will launch at the end of next month. There's general support from the tech industry for the code. I suppose general awareness that it's needed. And I suppose the main concern would be around alignment with international comparators, particularly the UK's age-appropriate design code, which is kind of well established now, having been adopted a couple of years ago. And so to the extent that we hear concerns from industry, it's more an anxiety that we're heading in the direction that they're already comfortable with, which is enshrined in the UK's code. And to avoid any doubt, we are certainly doing our best to align with that, or looking at it as a key area of comparison for the work that we're doing.
I'm just going to ask some questions around the automated decision-making and FOI as well. Recently, the OAIC published a report on automated decision-making and public reporting under the FOI Act. Can the FOI Commissioner provide an overview of the key findings of this desktop review of government agency transparency?
Thank you, Senator. If I might commence with a response to that question and then hand over to my colleague, the FOI Commissioner. This was a piece of work that looks at elevating systems and processes for dealing with information, specifically in the government sector. So it derives from both the legislation for the Information Commissioner and has a nexus to the FOI Commissioner, a very clear nexus to my colleagues' responsibilities in that regard. But we did rely upon the Information Commissioner statute to undertake this piece of work. We looked at 23 government agencies that were able to utilise automated decision-making, and we sought to do this as an educative process whereby we would make recommendations in a manner that wasn't too dissimilar to the approach we adopted in relation to messaging apps, to really highlight for the community the type of practices that would benefit the community in better understanding the use of automated decision-making and how we might provide adequate guidance as the regulator to ensure that agencies were able to adopt the practices that, from our perspective, better met the requirements of the FOI Act. In undertaking that review, we found 4 agencies that adopted the sort of practices that we were really considered integral to the operation of the FOI Act around operational information and information about decision-making. The other agencies, we were not able necessarily to identify that it was in use and that the the guidance that we would seek to advance was therefore being applied by agencies. So it was very much a baseline assessment and one aimed at providing greater guidance. The conclusion of the report was clearly that we as the regulator needed to look at our guidance too and to update the statutory guidance provided by the FOI Commissioner under those guidelines. I'll check in now with my colleague to see if there's anything else that she might like to add to that response.
That's great. Thank you.
Thank you, Senator. Alice Lineker, Freedom of Information Commissioner. So the report that was conducted on ADM is a consistent reflection of priorities within the OAIC to focus on IPS and proactive release of information by agencies. And so consistently with that, we're asking agencies to go and have a look at what they can provide so that FI requests aren't required or necessary. That's consistent with a number of conversations we've been having across the Commonwealth around attempts to reduce the number of FOI applications, look to schemes like admin access, but also really focus on IPS. And so the ADM report further supports that focus of the OAIC to look at what agencies can put proactively out into the public.
That's great, thank you. I think in my final question, I've only got a couple of minutes left, but I'm really keen, and I know that most Australians are very keen on how this might intersect with the Privacy Act and their privacy obligations, particularly introducing some new transparency requirements for ADM. Are you able to explain that for us?
Yes, thank you, Senator. The Privacy and Other Legislation Amendment Act that Parliament adopted in December 2024 introduced a new obligation on regulated entities to disclose whether using automated decision-making to make certain kinds of decisions, and that information has to be in their privacy policy. That obligation kicks in December 2026. The OAIC has a issues paper that will be published towards the end of this month, which sets out our emerging view on the various, on the interpretation of the various elements of the requirement, seeks input from industry and others as to any challenges they see with respect to complying with the obligation, and also enumerates a number of case studies. And from there, we'll be developing guidance to ensure that entities really understand what the obligation requires of them and are prepared to comply from December this year.
That's great. Look forward to the update in May. Thank you, Chair.
Thank you, Senator Cox. Senator Shoebridge.
Thanks, Chair, and thanks everyone for your attendance this evening. I've got some questions about the recent ruling by the ART on Bunnings to you, Ms. Kind. What's the situation with the decision? Is it under review for an appeal from your office? Do you have appeal rights in relation to it? What's the status?
Thanks, Senator. So we received the decision on Wednesday. We have 28 days from Wednesday to lodge an appeal, and that would be to the federal court, potentially to a full court of the federal court. We're obviously really giving that thoughtful consideration. It's a very important decision for the OAIC, and it's on an issue that the Australian community cares a lot about. So we're taking our time to fully understand the decision, to take advice and to give that consideration.
Yeah, and I appreciate it. You only got it Wednesday last week, and I'm not going to ask if you've made a final decision, but it's under review, the question of an appeal under review.
Correct.
When you look at the decision, it seems to uphold elements of your findings, but then suggests that, on my reading of it, it's saying facial recognition is permissible for everyone who comes and goes into a store, provided there's some clearer signage. Perhaps I'm oversimplifying it, but
no, people get their photos taken when they're in Bunnings, and they don't give permission, and they are published.
Well, this is the question. What do you understand the ART has said about how our privacy laws permit facial recognition?
So, Senator, you're right that the tribunal endorsed our decision on a number of different fronts with respect to APP1 and APP5, so governance and notification, and then differed from our view on APP3, which is really the substantive question. I don't want to be drawn too much into the decision, given that we're still giving it our review, but I would perhaps contest your characterisation. I don't think that the decision as it stands gives permission for facial recognition to be used in any context. I think the tribunal found that in the particular context it was justified under the relevant provisions.
All right. But what the tribunal found in relation to Bunnings was, given the measures they had in place with their facial recognition, data retention and data deletion, that provided they had clearer signs about the fact of facial recognition and provided they addressed some of their administrative shortfalls, that it wasn't unlawful in those circumstances, a breach of the Privacy Act, Principle 3, I think, to allow facial recognition in every Bunnings store.
The tribunal adopted the same analysis that we had in the determination, which was to consider a range of different issues. One of those was proportionality, under which fell those issues that you've discussed there around data retention, for example. Another set of issues was around the suitability of the technology to address the particular issues that Bunnings was facing. And a third set of issues was around available alternatives that might be less privacy intrusive. And I think they considered a range of other factors in addition to the ones you've talked about there.
But I know it's under appeal, so I had a series of questions here, but we might come back and revisit that after you successfully appeal it.
Sorry, it's not under appeal yet, just to clarify.
I'm being facetious, sorry, I withdraw that. Could I then ask about another place where facial recognition, and particularly in a retail context, has arisen, is the AFP's use in Canberra of Aura and their continuing use of Aura in Canberra. That's been a matter that's previously come to the attention of the Privacy Commissioner. There were concerns raised about their use. We now understand from further answers that the AFP and the ACT have used it hundreds of times in the last 12 months. What's the status, if there is any, of current oversight of the AFP's use of Aura?
Senator, we undertook some preliminary inquiries with respect to the use of Aura in retail settings last year, and we have decided to take no further action at this stage. We weren't looking at AFP use of that technology specifically. It's not an issue that's currently under consideration within the OAIC. Sorry, I should say not an entity that's currently under consideration.
What led you to form that view that it wouldn't be under ongoing consideration? There are significant concerns about its use, almost ubiquitous use in New Zealand, for example.
Yes, indeed. We consider a range of different factors when deciding whether or not to use our regulatory powers, so I couldn't speak specifically to the range of factors that fed into that decision.
Like what?
Well, it's okay. But do you have any...
What range of factors?
Sorry, Senator McKenzie, we are one senator at a time asking questions. Thank you.
Could I... But to be clear, are you aware of the extent to which the AFP and the ACT are using Aura, the hundreds and hundreds of occasions each year that they're accessing data out of Aura?
Senator, I don't have visibility of every tool and technology that police forces in Australia use. We make inquiries with respect to issues that come to us via a range of different avenues, including tip-offs, regulatory intelligence and complaints, and then we decide on balancing a range of different factors whether to take forward an investigation.
But you see, Commissioner, I'm not asking about everyone. Mm-hmm. I'm asking about one where there were previous concerns, because the AFP rolled it out without even doing a preliminary investigation about the privacy impacts, where there are significant concerns about this facial recognition being abused in New Zealand, particularly against the Maori community, and misidentifying people in the Maori community, and in circumstances where we had from the AFP, they're using it hundreds of times a year in the ACT. I'm not asking about just anyone, I'm asking about Aura. So I know you tried to respond to it in the way you did, but could I ask you to address those particular concerns about Aura?
But I'm sorry, Senator. What? Well,
you said, "Oh, you're not reviewing every piece of technology the police are doing." I'm not asking about every piece of technology police are doing. I'm asking about one which has very serious privacy concerns. Those concerns particularly impact. I know it's reported. Particularly nasty impacts against the Maori community, where this technology is used at scale in New Zealand. will you review the AFP's use of it in the ACT?
Senator, we have made some inquiries into Aura as a tool, a technology, and we closed down those inquiries last year, which is not to say that we wouldn't look at them again. I can't give any details into the particulars of the investigation.
Could I ask about the use? The OAIC was looking at potential data breaches for data that's gathered for rental platforms. You know, there's substantial amount of data that's now been asked before people, as people put a rental application in. Have you looked at the extent to which those platforms are potentially violating Australian Privacy Principle 11 in relation to documents being accessed via unauthenticated URLs, web crawlers and the like?
Thank you, Senator. We have, there's two categories of work that's relevant to your question. The first is that we have an ongoing investigation into a rental technology platform that will be concluded very shortly. And then secondly, we've also noted the recent reporting around security vulnerabilities in rental platforms, and we're making inquiries with the relevant entities about those.
Which rental platform is the subject of that advanced investigation?
That's not currently public information, Senator.
Which is why I'm asking it.
I'm not sure what the situation is. Yeah. I have to take that on notice, Senator.
All right. Could I ask you about what, if any, preliminary inquiries have you made about the vulnerability of people's identity documents, which are being uploaded at scale all across the country and held by third parties often at the request or direction of real estate agents? What's the state of that investigation, and how concerned should people be about the protection of their documents?
This has been a real priority issue for us, Senator. And indeed, you may have seen that we conducted a privacy sweep in January of this year in which we looked at 6 sectors, one of which was real estate agencies, and with a particular focus on the collection of identity documents, because, as you say, that is a real area of privacy vulnerability. We have focused on that, as I said, in our Commissioner-initiated investigations, and it's an area that will continue to be a focus for us. So the issue that you raise accords with our regulatory priorities.
Well, so people can perhaps take some protective action themselves when they're being asked for this intrusive information, potentially in insecure environments. What platforms are currently the subject of your investigation?
As I said, Senator, I have to take that on notice.
Well, no, that was about the one that's in an advanced stage, which was a separate matter.
Oh, with respect to the privacy sweep.
Yeah, the privacy sweep, I assume relating, amongst other things, to Privacy Principle 11 about data protection. What platforms have been the subject of that investigation by you?
I don't have that information before me, sorry, Senator. The privacy sweep focused on Australian Privacy Principle 1, however, which is around governance and policies and processes, not specifically on APP 11.
Well, can you provide that on notice, please, about which rental platforms have been the subject of that privacy sweep?
Yes. Yes.
Thank you, Senator Shoebridge. Senator McKenzie.
Thank you, Chair. Really appreciate it. Thank you so much. At the last Senate estimates, I asked the AG's department about the protection under Australian law of personal data of drivers in connected vehicles. And I put a few questions on notice, which have been returned, which said the responsibility of the OAIC was to investigate, in inverted commas, investigate complaints and undertake enforcement actions. And I understand as part of your regulatory priorities for this financial year, you've identified, and I quote from the Quon, new surveillance technologies such as location data tracking in apps, cars and other devices. What work are you doing with respect to investigating the weaknesses in the protection of Australian motorists' private data for misuse by foreign-owned auto manufacturers?
Thank you, Senator. I'll answer that. We have a number of active investigations into to vehicle manufacturers overseas.
So, okay, a number of investigations. Who, how many, what's the go?
Senator,
Ms Kind, I'm not interested in generalities today. This will be the third Senate estimates that I've sought specificity on this, whether I ask infrastructure and transport, whether I ask Home Affairs. I'm here for specific data on what we are actually doing to protect Australian motorists from foreign interference.
I'm afraid, Senator, I can't give you too many specifics. We have a number of active investigations underway.
Active investigations. Okay, let's go.
In order to
how many
afford procedural fairness to the effective respondents, I can't provide more information than that.
How many?
We have...
how many?
If I could just
consult
my notes.
Senator, while my colleague is just responding to that, I might add that the Privacy Commissioner's initiation of work in this regard has caused us to look at the practices of a number of manufacturers. And
which manufacturers, Ms Tate?
I couldn't give you all of the manufacturers.
Could you give me any?
I couldn't at this stage, given
Could you give me the number?
Sorry, Senator Mackenzie, can we just
could you give me where they're located?
Senator Mackenzie, can we please let the officials at the table complete?
No, because I have asked this with generosity, having been a former minister, having sat where Ms Green is sitting. Minister Green? I understand, well, let's be honest, Assistant Minister Green, but I have sat there and I have had to do this job.
At least.
So I have given the government enough bandwidth to really come to Senate estimates and articulate what is the government doing to protect Australian motorists from foreign interference. And I have yet to receive, and I'll be asking Home Affairs, Cooey or Home Affairs tomorrow when I have them in front of me. But the Department of Infrastructure and Transport in the last 3 estimates has been unable to afford me with comfort that there's been adequate oversight from the government on this issue. And I'm here today because I understand that you are the appropriate agency for which I should be asking these questions on behalf of the Australian public. How are you protecting them when they buy connected vehicles?
Senator Mackenzie, if I might respond by indicating that some of our investigative powers, as you would be aware, are coercive, and on occasions we are required to issue notices that are associated with penalties and that are compulsory.
Good.
We have an active investigation underway and we're not able to... That I have not indicated that that's against one target, Senator Mackenzie. It may be against a number of targets. And with any active investigation, we are not able to provide you further details of an active investigation.
But what you are able to do is provide me with the number. I'm not asking for you to compromise the Commonwealth at all in prosecuting a perpetrator against the Australian public.
I think my colleague
I am able to ask how many active investigations are underway. You don't need to tell me who they are against, but you should be able to tell me how many, if they are differentiated, which geographic locations they may be from. So these are not questions that are compromising your investigations or your responsibility, shall I say, on behalf of Australian taxpayers to take these people to court. But what I am seeking to understand is how many and where they're from, and broadly under what requirements.
Thanks, Senator.
Thank you so much.
I'm happy to report that we have two open investigations. Sorry, we have open investigations against two separate entities. We conducted further preliminary inquiries against a further two separate entities, but did not decide to take those forward into investigation.
Is that because you want to be a prosecutor or of good report or best practice?
The way we conduct our investigations.
Why did you determine not to prosecute those other two entities?
As I said before, Senator, not to provoke you, but we take into consider a range of different factors, and that would also include the likelihood of or the presence of a potential breach and the likelihood of establishing a breach. So we may look at an entity and conclude.
So you didn't think you had a good case?
That may be one of the factors that we take into consideration. But we have two investigations opened against two separate entities, both of which are foreign-owned vehicle companies.
Are they both located in the same geographic area?
What do you mean by geographic?
Continent. Are they both European? Are they both American?
They're not European entities.
Are they American?
No.
Are they?
They're both in the Asian continent.
Thank you so much. I really appreciate that. But two separate entities.
Correct.
Are both state-owned?
I couldn't give you that information, Senator.
On notice, I'd like that. Whether they're state-owned and supported enterprises, or whether they're... Because we wouldn't like to incorporate South Korea or Japan. Are they Japanese?
I can't.
Are they South Korean?
Senator,
Are they Vietnam? Are they Malaysian?
As I said, we don't comment on active investigations. I've given you the information you've asked for.
I would like to understand whether they are both from the same... We say continent, but I'm going to say country. On notice.
Senator Mackenzie, I'm communicating 1 minute left.
Oh, really? I've got a whole suite. We'd only gotten started. Have you met with foreign-owned manufacturers such as Tesla, BYD, Chery, Polestar and others to satisfy yourself of the data tracking capacity of these businesses?
I have not, no.
Has anyone, minister in the department, met with these foreign-owned car manufacturers, Tesla, BYD, Chery, Polestar and others, to satisfy the government that the data tracking capacity of these businesses wouldn't compromise the privacy of Australian citizens?
I don't have information on that, but I can
Secretary
for you. And
Secretary,
ask the
I'm sure the
department
Secretary will be able to answer me.
Thank you.
No, thank you, Senator Green. I understand you don't have that information. Does the official next to you have that information?
Senator, not to my knowledge that anyone in the department has met with them, no.
No one in the department has met with the major manufacturers, particularly out of China, about their ability to track Australian citizens who've purchased their vehicles. Is that correct, Secretary?
That is correct, Senator.
Senator, I'm going to share the call.
Sure.
Thank you. Senator Shoebridge.
Thanks very much, Chair. No, it's okay, Bridget. Can I ask about the what, if any, involvement the OIC has had with Home Affairs about the ongoing negotiations between the Australian government and the US about enhanced border security partnership? This is the arrangement under which Australia is proposing to hand large amounts of Australians' biometric data over to the US Department of Homeland Security. Has there been any consultation with the OIC about those negotiations?
To my knowledge, Senator, no.
Do you know if arrangements that are negotiated between Home Affairs and the US Department of Homeland Security, if they're going to involve the potential large wholesale handing over of biometric data and other information critical to people's privacy, with the United States, would that require a privacy impact statement from Home Affairs before they enter into those arrangements?
Sorry.
Thank you.
Sorry, Senator, could you repeat the question? It was whether a privacy impact assessment was required before entering into such an arrangement?
Yes. Well, Home Affairs is at the moment in detailed negotiations with the Trump administration about arrangements under which Australia's biometric and ID databases will be opened up to the US to provide biometric and ID information from Australian databases to the US Department of Homeland Security on Australians who travel from Australia to the United States. Does that require, before they do that, or before they implement it, should we expect a privacy impact assessment from Home Affairs?
If you'll give me 1 minute, Senator, I'm just clarifying with my colleague.
And while you're doing that, just to give you some flavour of the information that's been required from the US, in addition to biometric data, facial recognition data, surnames, first names, former names, other names, aliases, alternate spellings of names, sex, date and place of birth, current and former nationalities, passport data, number of other identity documents, biometric modalities such as facial images, criminal, police and immigration records. That's what Home Affairs is proposing to give to the US under these enhanced border security partnership.
Sorry, the high risk. High privacy risk project. Yeah, thank you. Sorry for the delay, Senator. I was just asking my colleague to help with the wording in the legislation. The requirement in the Australian Government Agencies Code under the Privacy Act is to undertake a privacy impact assessment for high privacy risk projects. I hadn't previously turned my mind to whether or not this would constitute a high privacy risk project, but if it did, then a privacy impact assessment would be required.
Right. So an arrangement under which, and I read the list of data that the US is seeking, surnames, first names, former names, other names, aliases, alternate spelling of names, sex, date and place of birth, current and former nationalities, passport data, numbers from other identity documents, biometric modalities such as facial images, criminal, police and immigration records, where that's been proposed to be handed over by Home Affairs to a foreign government on a routine systemic basis, just when Australian citizens travel there. Do you think that might meet the high risk test?
I agree it's an extensive amount of information, Senator, which clearly raises privacy issues, and I would have to turn my mind to the exact requirement in the code, but I can see that there are clear privacy risks involved in that, so I imagine that the Home Affairs is giving that some consideration.
Well, there might be. Are you aware of the concerns that many in the United States have about information that's with their Department of Homeland Security being then handed to multiple other parts of the US government, whether it's ICE, which is one part of Homeland Security, or other parts of the US government for potentially prosecutions, adverse action? Are you aware about those concerns about information passing in the US?
I don't have specific awareness, okay. Senator.
Do you agree that there are particular privacy concerns if the Australian government hands data to a foreign country? Because once it's been handed to the foreign country, remedies that might be available otherwise under the Privacy Act for deletion or correction, they obviously can't be exercised if the information's with a foreign country.
I do agree with that, Senator, and that is one of the premises of APP 8, which requires entities to be satisfied that there are privacy protections in place when they're transferring data across borders.
Yes. Well, indeed, you know, it seems to me not only is APP 8, which is about the cross-border disclosure, that's engaged here, but APP 6 about use or disclosure of personal information seems to be engaged as well, doesn't it?
That's correct, although there are specific provisions in APP 6 related to information disclosed by the Immigration Department, so I would have to take a look at those specific provisions as to how they interact with this proposal.
Were you aware of these privacy concerns involving the negotiations between Australia and the US under enhanced border security partnership before this line of questioning?
It's not something that our office has been consulted on, to my knowledge.
Having been advised of having had this discussion now, will you undertake to review it?
I will.
Do other government agencies, when they've got very potentially serious privacy issues arising in their course of their operations, do they actively reach out to you and seek some cooperation and advice?
Agencies do seek our advice from time to time. We're, of course, the regulator, so we are careful to make sure that we maintain our role as the regulator, and our job is not to provide policy advice, and we generally refer agencies to the policy department, AGD.
All right. But to be clear, that hasn't happened from Home Affairs in this space?
Not to my knowledge.
Okay. All right. Just to close, one question on what Senator Mackenzie was asking you about the privacy concerns for the data being collected from motor vehicles. One of the concerns that's been raised publicly is that Tesla, for example, has active monitoring of what is being said in a vehicle and having voice monitoring of what is being said in a vehicle. Has that issue been raised, and then that information is being provided back to Tesla headquarters in the United States?
Yeah.
Has that issue been raised with you?
Generally speaking, we are looking at voice monitoring in vehicles. I can't speak to the specific entity you've named, but that is one of the privacy concerns that has been raised up to us through public reporting.
You see, Minister, shouldn't the Privacy Act just say it is unlawful?
That's right.
It is unlawful to, without people's knowledge or without their consent, monitor, record and transmit voice recordings of what people are doing in their car. Shouldn't it just be unlawful?
Well, Senator Shoebridge, as you know, the government's position is that the Privacy Act is out of date and needs updating. That's why we're working on broad-scale reforms of the privacy legislation. We did pass legislation in 2024, I think in the last term of Parliament, dealing with some aspects of privacy. We're working on the second tranche of those reforms. We certainly will be looking at all of the aspects that we can include to make sure that the Privacy Act is fit for the digital age, which is something that you've referred to. Most importantly, hopefully we'll get the support in Parliament to carry those laws through. Unfortunately, you supported the privacy laws when we did pass them. Unfortunately, the opposition didn't vote for those privacy laws back then. They voted against giving Australians the right to take action against serious invasions of privacy, and now they're pretending that they're interested in privacy of all Australians.
Final question, Senator Shoebridge.
Yeah, but Minister, I want to be clear. If your government brings in laws that significantly enhance our privacy rights and make them fit for purpose in the 21st century, we've told you before, you have a pathway through the Senate to get that done with my party. But we have been waiting now for 4 years for significant reforms in the Privacy Act to happen. The reforms that happened at the end of 2024 were modest, to say, it's polite to call them modest.
That's your characterisations.
Hardly touch the sides. But every day we don't have 21st century privacy laws, we have people's conversations being secretly recorded when they're driving their car and being fed back to Uncle Elon.
Here, here. Elon
Senator
Shoebridge,
Senator Shoebridge, as I said to you, we are working to progress the next stage as quickly as possible. We have said that the Privacy Act is out of date, particularly because of the digital age. I don't agree with your characterisation that the first tranche of reforms were modest, and we look forward to bringing forward the second tranche of reforms.
Thank you, Senator Shoebridge. Senator McKenzie.
Thank you so much. I've been, in my former role as Shadow Minister for Infrastructure, Transport and Regional Development, I've been pursuing the interest of Australians in cars being listened to by foreign entities and having their privacy trampled on. And I have no comfort from the Department of Infrastructure, from the Department of Home Affairs, and I'm hoping I get some comfort from Ms Jones that the Attorney General's Department, who I've been referred to by previous departments, that the Attorney Generals are looking after the privacy of all Australians, that there is some comfort that their actions, that their conversations, that their thoughts are not actually being subjected to foreign interference. So I want to understand from connected vehicles, what action is the Attorney General's Department taking to secure Australians' privacy?
Senator, it's not an issue that we're actively looking at.
Wow.
I think, though, I note that Ms Kind has indicated that appropriately, as the privacy regulator, they have 2 active investigations on at the moment.
So what about the United Nations motions that we're looking to actually globally impact private citizens in a range of nations' right to have conversations within vehicles, travel to where we want to travel to, without that being subjected to data being relayed to foreign entities? What can the Attorney General's Department articulate that you're actually doing anything to secure our privacy, not just here at home, but globally, from these global entities?
Sorry, I didn't quite get the reference about the United Nations.
So, as I understand it, there's UN Convention number, I think, and I'll check last Senate estimates, I think it's 157, 156, where there is a global conversation about connected vehicles and how we actually protect citizens' data in that context. But I'm wanting to know what the Attorney General's Department and the privacy aspects within the Attorney General's Department, are you even involved in these conversations with the Department of Infrastructure or the Department of Home Affairs, or are you not? Because I've been referred to you, which is why I'm here tonight.
So, Senator, we are aware that consideration has been given to issues by those departments.
Oh, you are aware.
From our, in terms of our responsibilities, we are working on a second tranche of privacy reforms, and that will consider privacy settings.
So sorry, and I can't read, I'm old.
Sarah Chidgey,
Thank
Deputy
you,
Secretary.
Ms Chidgey. Can I, in the global language that you just used, can I drill down, because I only have a certain amount of time? Are you actually considering in the second tranche of privacy reforms connected vehicles and protecting Australian drivers in these next tranche of reforms from the Labor government? Yes or no?
We are considering these issues.
And so specifically when it comes to drivers, what are you considering?
That'll ultimately be a matter
of government.
For government. And
sorry, I've been a minister, I get that answer.
Reforms.
I understand, it's a matter for government. So what directions has the minister given you for considerations for the briefs she will be considering as Attorney General?
So the Attorney-General has made it clear that the second tranche of privacy reforms needs to provide both for innovation and for the protection of the personal data of
On
Australians.
connected vehicles, I've made it very clear what my area of interest is. I've got limited time, which is the chair's right. So I want to be very specific. I'm not interested in global motherhood statements from the attorney with her drafting instructions. I'm interested to see if she's drilling down on the safety and privacy issues of Australian motorists when it comes to connected vehicles, yes or no?
Senator, the Privacy Act principles apply across all types of technology and set those standards.
Has the Minister made it clear to you that this is an area she wants to be clear about, given the amount of, particularly given the Minister for Energy's desire to have 50% of our passenger vehicles to be EVs by 2035? I would suggest that without the attorney giving consideration to privacy impacts, despite the great gains on emissions, we might be sacrificing everything for nothing.
I think connected vehicles, the connected issue, I think is...
Was the attorney clear with you, Secretary, that she wanted you to be giving her recommendations with her second tranche of reforms around privacy, around connected vehicles, yes or no?
Senator...
I've been here. I know what a minister says and does. Did she... I am asking the question, Senator Polly. If you would allow me, without your inane interjections, I'd be able to get to the bottom of it. Secretary?
Yeah, definitely.
One of the general areas that we're looking at is around consent to handle precise geolocation tracking data and to trade personal information. So that is one of the general areas that we're looking at. So
voice and geolocation for connected vehicle drivers is something that you've been tasked with, yes or no?
Senator, the Privacy Act is neutral as to individual particular technologies, and we would intend to maintain that principle. In the second tranche of reforms, we're looking at how the principles in the Act apply to developing digital technologies, and that would include this, but we don't regulate a series of specific technology
So how
applications.
Would purchasers of connected vehicles be assured that the federal government has regulations in place to protect their data?
Senator, I think we outlined in the answer to a question on notice the principles in the Privacy Act, and we'll obviously take account of the work that the Privacy Commissioner is doing to look at connected vehicles.
I'm just indicating last question.
Okay, last question. How can the government assure purchasers of connected vehicles that their data is secure as of today?
So the Privacy Act has requirements for security of personal information, but that is also different to some of the security requirements. That
is it secure?
We're not the regulator who's
regulator. You're all at the table. This is what infuriates Australians. You're all here. They've asked me to ask about the security of their data. No one is able to answer my question. I open to all the women at the table today. Who is prepared to say how secure people's data is in connected vehicles today? Anyone?
Senator, I think you've indicated you're going to speak to Home Affairs tomorrow.
Wow. And they'll refer me to you. I've done this before, Secretary, so that's why I'm here. I'm not an inexperienced senator here.
No,
I've been the minister and I've directed secretaries, and I want to know if you've been directed by your minister or not. And from the women in front of me, none of you have been directed by the Attorney-General to secure Australians' data when they're in connected vehicles.
Senator
If you
McKenzie.
have a different view,
Senator
ladies,
McKenzie.
this is
Senator
the time to stand up.
Senator McKenzie, we've provided you a number of answers tonight. I think the problem is you're not
You've done a
listening to those
wonderful,
answers. Senator McKenzie,
Wow.
the regulator is investigating the matter, and the department is working on
These
privacy
ladies
reform.
are
Why do you
intelligent,
keep calling everyone ladies? It's
competent.
so
No, but
unnecessary.
we are ladies. I'm a lady.
Suspend
They're
I'm not
also
rude.
they're commission.
Thank you. We'll now resume broadcasting, and we are now in a position to release the Office of the Australian Information Commissioner. Thank you very much for your time this evening. We will take a short suspension while we welcome the Federal Court of Australia. Thank you. We will now resume broadcasting with the Federal Court of Australia. And Ms Lagos, do you have an opening statement?
I don't, Chair. Thank you.
No worries. We will proceed directly to questions. Senator... Oh, sorry. No, sorry, Senator Shoebridge.
Sorry. Thanks, Chair. Thank you all for your attendance. The Family Court and the Federal Magistrates Court and the Federal Court, between you, I think have a contract. Is it with VIQ Solutions for transcription services?
Yes, it is, Senator.
I can't hear you through there.
Sorry. Is that better?
I can hear you now, yes. Yes, so you have a contract with VIQ Solutions for transcription services?
Yes, we do.
Yeah. And I think the Federal Court sort of is the lead, is it, for the two courts, negotiations and contract management for the VIQ Solutions? Is
The
that
Federal
right?
Court, in its capacity as the listed entity only, not as the court, so to speak, so in its corporate services administrative role, supported the courts in 2019 to enter into, or basically deal with the procurement and open tender relating to that contract.
All right. And I think VIQ Solutions purchased Ausscript in about 2021. Is that what happened?
The initial
contract.
The initial contract was entered into with Ausscript Australia Proprietary Limited in, I think, October 2020, and that contract was novated to VIQ Solutions subsequently.
And it required your consent, I assume, to novate it?
Yes, it did.
At that time, were there restrictions on VIQ offshoring transcript and offshoring audio?
Absolutely. The restrictions are contained in the very specific clauses in the contract, clauses 51 to 55, that expressly provide for that.
All right. The prohibited, is that right?
Yes, that's right, Senator.
Are you aware of what subcontractors VIQ Solutions is currently using for its transcript?
No, we are not aware of any subcontractors having been engaged by VIQ Solutions.
Are you aware that VIQ Solutions is now using an AI-based software called NetScribe? Are you aware of that?
No, we are not aware, Senator.
Does VIQ Solutions have an obligation to keep you informed if they're making significant changes in how they're operating?
The specific clause provides for VIQ Solutions providing both recording and transcription services, and that specifically provides for them to do the digital recording and the manual transcription of transcript.
So does it prohibit them using AI-based software for the transcription?
From our lens, yes, it does.
Have you undertaken any checks as to whether or not VIQ, in breach of that, is using AI-based software, particularly NetScribe?
We have formally written to VIQ, specifically requiring them to confirm that they are complying with each of the terms specifically to that issue in the contract.
When did that correspondence go?
Last week.
Last week?
Yes, it did.
Are you aware that NetScribe is owned and operated by E24 Technologies?
No, I'm not aware, Senator.
Would you be aware that E24 Technologies is uses offshore contractors for its transcription services based in India? Are you aware of that?
I don't have any such knowledge, no.
Have you undertaken inquiries as to whether or not VIQ Solutions, separate to the letter you wrote a week ago, VIQ Solutions is offshoring any of its transcripts to India?
Sorry, Jimmy Mastarakis, Executive Director, Corporate Strategy and Programs. Through the regular contract meetings with VIQ, they're required to seek our permission if they are going to use either a subcontractor or offshore or use any sort of AI technology in their transcription, and they have never sought such permission. So those matters are discussed regularly through the contract management meetings that we have with them.
What ongoing integrity tests and checks has the Federal Court been undertaking in relation to these external transcription services over the life of this contract? What, if any, integrity checks have you had in place?
Beyond this very express and explicit provisions that specifically prohibit any such arrangement, the contract expressly provides for regularised meetings. Management representatives for what we call our court and tribunal services have regular meetings on a monthly basis and a quarterly basis with VIQ in relation to performance, contractual arrangements and any such issues, because they are the conduit for all three courts in relation to those services. Those services and the performance of those services to the standards required are paramount to the court's operations, and none of those matters have been canvassed to provide any permission for any subcontracting arrangements or use of generative AI.
Well, if they're in breach of the contract and they're providing transcript offshore in breach, they're hardly going to volunteer it at quarterly meetings, are they? They're going to say, I just want to let you know, I'm in gross breach of the contract and I'm providing it offshore to cheapen, to lower my costs to a subcontracted entity in India. They're not going to volunteer that, are they?
Well, we have specific and express specific contractual obligations, and we intend to verify those issues and deal with it in terms of any consequences regarding the contract.
Will you provide this committee with a letter that you've sent to VIQ Solutions, please?
I will take that on notice and provide that letter.
Again, you're relying on VIQ Solutions, the genuineness of any response from VIQ Solutions, but if the concerns that have been communicated to my office are anything to do with, they haven't been volunteering in a genuine way anything about their changes to their services, if you could call them that, in any of the quarterly meetings, Is that what you're going to rely upon, just simply a letter? You're not going to require a forensic assessment, some kind of independent vetting or independent audit of what's been happening to people's transcript?
Well, having regard to the response that we receive, we will take these matters extremely serious, Senator. I mean, the sanctity of the court's data in relation to recording and transcription is an extremely important issue.
Well, you say this, but concerns were raised about the potential breaches of VIQ Solutions contract not a week ago, but months and months and months ago. In fact, in the last Senate estimates, I raised issues with the Federal and Family Circuit Court and the Family Court. There's been ABC reporting about it, and I want to commend the ABC reporting that's been done about this. Between then and you sending the letter last week, what happened?
There were informal communications at a more at management levels, but we considered that it was important for us to formally write to VIQ to ensure that we got written confirmation in relation to their compliance with the contractual terms in relation to those specific issues. And we provided them with the information from the Senate estimates process and the reporting in the media as well, to say we have very expressed concerns regarding these issues and we want them to confirm that they are complying with their legal obligations.
But you wait until just a week before Senate estimates before doing that. What explains the months and months and months of inaction up to then?
We were seeking the legal framing for that and wanting to consult with each of the courts in relation to those matters.
You understand, don't you, why there are strict security requirements around transcription, why people engaged by VIQ Solutions or any entity doing transcription of federal court matters needs security clearance and vetting? You understand that there's a reason for that, don't you?
Absolutely. That's why it is so expressly provided for in the contract terms.
But it's also why you should be doing your job on an ongoing basis to check those contracts are being complied with, isn't it? Surely it's an obligation of you, in the form of the federal court, double-checking that incredibly sensitive information that may be given in closed court, that may be about criminal matters, it may be about national security, that information is being treated consistent with the contract and only being provided by people who have been given security clearance and vetted. And what have you been doing to check that over the last 5 years?
It is expressly provided for in the contract terms, in the clearest possible terms, and is the subject, I'm advised, of regular communication in general terms.
Yes.
Registrar, previous life I was involved in managing major contracts. It was quite typical. You'd sometimes have an external audit function, so someone would actually be engaged by the principal to actually audit compliance, so you weren't simply just relying upon a bare contractual term, but you're getting some sort of independent report. Has there been any independent audit undertaken with respect to the performance of the contract?
Senator, not that I'm aware of, but if you look at the services that is provided by VIQ, not only to the federal courts, plural, but to a number of federal and state-based agencies, they have a very extensive operation, and they specifically articulate the significance and the importance that they place in data security, storage of data, not allowing access and transfer of data by any third party. So it is their specialised service that the court has contracted with, as it did with Auscript before.
I appreciate that, but there are in many contexts where you have major contracts, they're providing specialist services, but you actually have a system where you can potentially appoint someone to conduct an independent audit to actually go behind the scenes, see what's happening behind the scenes. It's often referred to as an open book policy, open book provision, so you can see everything that's going on. They have access to all the staff, they have access to the operations, and it can be a very effective way to undertake a QA/QC as to whether or not someone's actually complying with the terms. So that sort of process hasn't been adopted in this regard.
Not that I'm aware,
Okay,
but I
thank you.
certainly, in the face of the concerns, it's something that we will absolutely consider.
Thank you, Senator Scarr. Senator Shoebridge.
You see, just trust isn't an integrity measure when you're dealing with a for-profit corporation that's headquarters are offshore. Do you accept that trust, that they'll stick to the contract terms, is not an effective integrity measure when we're talking about a government agency, in the case here the Federal Court, dealing with incredibly sensitive information?
Senator, the courts have outsourced and had private contractors providing these services for over 20 years, 30 years, thereabouts, once it was privatised, and have relied on that being specialist services that they are contracting, and hence the strongest possible caveats in relation to the security, data storage, no transfer offshore, explicitly been stated, the sanctity of it being confidential information, the specific requirements for this entity to comply with all elements of the Privacy Act, to comply with all of the security standards, including the PSPF. So these are all very explicitly stated elements of the service.
Well, we could have a philosophical debate about just how wrong it is to privatise corporate government services like this, but that's not what I'm getting at. But I want to be clear, it is totally wrong to privatise core government service like this, and this conversation is proving why. But the putting in place contractual terms and then walking away from it and hoping that all's good for the next 6 years is not an integrity measure. That's hope, and it's hope when your counterpart is a for-profit foreign corporation. And so the truth is you have no idea what VIQ Solutions has been doing with Australian data, with Australian transcripts, because until you sent a letter last week, you didn't even ask. That's the truth, isn't it?
It has been the subject of regular monthly meetings and quarterly meetings with VIQ, and the issue of protection of data is part of those meetings, including the requirement to report any data breaches should they occur, and including the requirement to provide the clearance of staff that work on transcripts as well.
Did VIQ in any of those meetings tell you about the large number of quality and insurance personnel that it sacked from its team and how they were going to make good that massive loss of personnel? Did they disclose that to you?
No, I'm not aware of that, Senator.
Did they explain how if you sack all the humans who are doing the work, did they explain how the work would then get done if all the humans stopped doing it? Did they explain that to you?
I'm not aware of that, Senator. No.
Are you aware, for example, that earlier this month did they tell you that VIQ restricted the WA Departments of Justice portal for its Australian staff? They stopped Australian staff accessing the WA system. And did they explain if Australian staff weren't accessing it? Did they explain who was getting access to the transcripts from WA?
I'm not aware of that, Senator, no.
You see, the Federal Court deals with matters involving ASIO, the AFP, federal criminal proceedings. A chunk of that doesn't happen in open court, a chunk of that happens in closed court. And you don't have any idea what VIQ Solutions is doing with that transcript, do you? Other than they haven't told you they've breached the data and are sending it off offshore. They haven't told you.
That data is very specifically characterised as data that is confidential and must be treated in a very specific manner to comply with all Australian law and security requirements, and they take on that obligation as a service to the courts. They do that on behalf of not only the federal courts but other multiple federal agencies that also deal with secure and sensitive data, and they have the systems and processes in place to give us that assurance in accordance with the contract terms. Now, the matters that you are raising, Senator, cause us concern, as they should, and we will absolutely drill into those issues as a matter of priority as we've started to.
Secretary, I think it's pretty clear that the federal court listed entity has minimal corporate capacity to deal with, you know, the circumstances that they're confronting here, the ability to get an independent audit, to get someone to look into VIQ solutions. They don't appear to have had any consideration or expertise in that regard to this point. Will the department reach out to the federal court listed entity and try and give them a significant urgent uplift and suggest ways in which you might be able to help them with providing perhaps a forensic audit or some other kind of check?
Senator, the federal court entity is an independent organisation in the portfolio. We, of course, will look to support any agency in the portfolio that requires assistance, but not in a way that in any way undermines their independent operation.
I'm not asking you, but, you know, letting an independent agency sink is hardly a good solution. If they haven't got the in-house capacity to start coming up with the solutions, how they can perhaps compel an independent forensic auditor, how they can get behind, get and have a look under the bonnet of VIQ solutions, surely it's incumbent upon you to offer some help and assistance, isn't it?
Senator, I have confidence that the federal court entity will take whatever appropriate action is necessary.
Okay. Well, I don't share that confidence after this exchange and hearing that the integrity measures that the federal court have done to date as disclosed in this exchange. But, Minister, do you share the Secretary's confidence with the federal court?
Yeah, look, I mean, Ms Lagos has said that they take this matter very seriously and taking steps to... I'm not aware of the allegations you've mentioned, and I'm not sure. You do have a habit of coming to Senate estimates and putting things to witnesses that may or may not be true. So I just want to be clear. I'm not sure of the complete scope of what you're referring to, but what I would say is that the court is independent, but the court's given you assurances tonight that they take this matter very seriously, as they should.
All right. Well, we'll wait to see the letter, maybe.
Yeah.
Chair.
Thank you, Senator Shoebridge. We are now in a position to release the Federal Court of Australia. Thank you very much for your time this evening. We'll take a very, very brief suspension while we welcome the Federal Circuit and Family Court of Australia. Thank you very much. We now welcome the Federal Circuit and Family Court of Australia. I understand you've provided the opening statement to the committee, and I'm wondering if we can table that and proceed directly to questions.
Thank you, Chair. Yes, I'm happy to have that tabled rather than read it out. There is a short statement I would prefer to just make, on behalf of the courts, it'll only take a minute, if that's okay.
Sure. No, I appreciate your indulgence.
Thank you. And I just want to note also David Pringle here, CEO and Principal Registrar of the Federal Circuit and Family Court of Australia, Divisions 1 and 2. I appear with my Deputy CEO, Virginia Wilson, and a number of senior colleagues as well. The opening statement that I've tabled really concerns rural and regional Australia and First Nations parties and how the courts are dealing with supporting rural and regional Australia as best as possible, as well as what things might be able to be done to enhance support in those areas. However, before we go into any of those matters, if we do cover them this evening, I take this opportunity on behalf of the courts to express our sympathies for and condolences to the victims and their families of the attack which occurred in Bondi on 14 December. A number of the court's judges and staff were directly affected by what occurred as local residents and given their Jewish faith. All of us in the courts are deeply saddened by this hateful attack, and our hearts go out to all of the victims and their families. To ensure that we are properly informed about the challenges posed by anti-Semitism, the Chief Justice has acted quickly to set up a working group, which I will be part of, to ensure that he is properly advised on how to keep our judges, registrars, staff and all court users safe. Chair, beyond that, I'm happy to speak to any of the matters in the opening statement, but I'm conscious of time.
Thank you very much for that. We'll proceed to questions and start with Senator Blythe.
Thank you very much, and thank you for your opening statement. And I've sort of briefly tried to skim to make sure I'm not asking you questions that you have provided in that document. I will go into family violence programs. I think it's an area that we all agree on in terms of wanting to make advancements. It's never nice for families to have to interact with the family court system, and certainly those that are experiencing family violence and separations and so forth. It's incredibly challenging. So I guess from your perspective, do you have the resources that you need to adequately support these vulnerable people as they try and navigate the family court justice system?
Thank you, Senator. We're grateful for the recent extension of funding we received to the Lighthouse program from government in MyEFO toward the end of last year. That was a 2-year extension to the Lighthouse program, which is really the backbone of much of the family violence measures that we have within the courts. We do feel that that is something, although there was a slight reduction in that funding, we do feel that that is something that shouldn't be done in a short-term sense, but should be plumbed into the entire operations of the courts, given that it is actually now fundamentally part of the case management structure of the courts. Beyond that, the short answer, I think, to your question is that more can and needs to be done. Yep. We're appreciative of that funding, but there are genuine gaps that need to be addressed. For Lighthouse itself, it doesn't extend to much of regional and rural Australia. It doesn't cover circuit locations. Circuits form roughly 1 in every 5 of our filings in the courts. So it is a program which is doing very well, but it tends to cover city and larger registry locations more than other locations. So, for example, if you are dealing with a parenting dispute in Newcastle, you would have the Lighthouse program, but if you're in Lismore, you might not. And those sorts of differences we feel need to be closed. Beyond that, Lighthouse program also doesn't cover property disputes. It covers parenting. Okay. And in our view, First Nations families require some additional support in order to be able to screen through the process as much as other communities do. Outside Lighthouse, there are a number of locations that don't have safe rooms and other support facilities to the level that we would appreciate. We think that is necessary to keep vulnerable parties safe. And generally speaking, regional locations in particular do need some additional facility support. Now, we're appreciative of the tight fiscal environment, but some of these locations have gone without additional property enhancements for quite some time. There are many other parts of the court's operations that we feel could be enhanced as well. I don't know how much detail you'd like us to go into, but there's certainly more training and support, education that we need to undertake, and all of that, of course, costs money as well. But ultimately, it's a very successful program, what we do, and we are confident that it can do more. We feel that we should try and go out on country to try and meet First Nations families and parts of rural and regional Australia. We would like to set up digital hubs that allow people to be able to access from regional parts of the country our electronic hearings, because of the digital divide that exists effectively. Many people just do not have access to proper internet and to devices. And the fact that for our court children's service, when children and parents are being interviewed, it is difficult for them to go out and meet the families in these remote locations. It forces families to have to come in from a very long distance, and that can be a real issue as well. So there are a number of areas I could go into perhaps on another occasion in more detail. We have a very good backbone to the system. We cover many parts of the country very well, but there are those sorts of gaps that I think we can try and close for a number of families.
That's fantastic. Thank you very much. And it's great to hear an agency that has a plan in terms of what they're wanting to implement and where the shortfalls are. In terms of caseload, do you feel as though you've got adequate staff to be able to manage that? Because I'm sort of aware there are some backlogs where some of these families, part of the trauma is actually having to wait a long time for their cases to be heard and findings to be made. Is that another area? Because the support sounds like you can always do more, but I guess on the other end.
It is a matter at times of stretching the resources to make sure you cover increased filings. Family law filings went up about 3 or 4% on last year. When you're doing about 100,000 filings a year, that's a significant amount. But it extends beyond family law as well. In general federal law, we went up about, I think, 27% on last year. Small claims, fair work matters went up 108% alone. And of course, the big growth area is migration, where our filings have exponentially grown, I think 64% last year. They continue to come in at an incredible rate. Again, some of that has been very effectively covered from government funding in recent times, particularly in migration. But the rate of growth of filings is outpacing the ability for us to capture all of them in the way we would like. So, short answer is yes. I think we could certainly do with some more, but we're conscious that it is a tight fiscal environment, and we know that government has supported in a number of areas as well.
Fantastic. Thank you very much.
Thank you, Senator Blyth, for your efficiency. Senator Polley.
Thank you, Chair. I have some questions around the Lighthouse program.
Yes, Senator.
I understand that the Federal Circuit and Family Court of Australia piloted and is now using this new program to improve the safety of litigants to family law matters. Can you actually just outline the Lighthouse program? What does that do in way of engaging with people that is going through the court system that is different?
Yes, thank you, Senator. It is really a groundbreaking program. It is one that was developed jointly by the courts and with Relationships Australia South Australia and Professor Jen McIntosh, where a bespoke application was designed so that people could screen in a confidential way with very straightforward questions, which would allow for that screening tool to identify the risk level as high, medium or low. The high-risk matters then get triaged by a highly qualified triage counsellor who can then further assess the risk level and also interview the high-risk litigant and refer them off to support services. That is really, as far as we're aware, a pioneering part of a court being involved in. That is to make direct referrals to support services from the court structure itself, rather than through wraparound services. We, of course, liaise with a number of very good wraparound services, including FAS and in the process as well. Beyond that, if the matter is identified as high risk, it will go to what we call the EVIT list, which is a high-risk list, specially resourced, intensively resourced through the government funding received, with registrars and judges specially trained in that area to be able to deal intensively with these higher risks, because at the moment the allegations of family violence in our parenting matters made by parties is at 86% of our parenting disputes. And the Lighthouse program itself has shown that through careful analysis of the data, 61% of matters are screening as high risk. So the work that's done in this area of Lighthouse and the high-risk cases in particular is really important. Our court child experts do extraordinarily good work to make sure that those matters get priority child impact reports as well. And so the system is carefully calibrated to try and deal with those high-risk matters. If the matter is not high risk, then it is streamed into a pathway that tries to facilitate dispute resolution as quickly as possible. But it's very successful, and even the high-risk matters tend to be resolving within about a 12-month period overall, notwithstanding the real complexity to those matters. The overall benefit of Lighthouse is therefore that we provide people with support services that don't otherwise necessarily have those services, and we calibrate these high-risk matters onto specialist pathways so that they get the right support that they need.
So how many officers of the court and judges are involved in this project? Have you got a figure that you can provide to the committee?
Yes, I might check with my colleague here in a moment, but my memory is that the funding through the Lighthouse program funded about 71 FTE of staff. That includes registrars, court child experts, and a number of support staff as well, and management, to be able to undertake that specialist work.
There's obviously benefit for those going through the court process, but are there benefits that you can demonstrate for the courts themselves in terms of, is there greater efficiency, better outcomes? Have you got any information that you can provide to us?
Thank you, Senator. Yes, I think the additional funding that was received obviously provided additional human resources, and in a court or courts as busy as ours, any additional human resources are very, very important to be able to spread the work sufficiently well. Our judges and registrars and others do an extraordinary amount of hard work and really complex cases. There is no such thing as an easy family law case anymore in our system. And the additional human resources that we received have been helpful in spreading the load of those complex cases where they need to go.
Thank you for that. Just in terms of those outcomes, fantastic to have that updated information, but what's the courts doing to support for First Nation families interacting with the courts, and how are the Indigenous family liaison officers supporting First Nation families, and how are they having, how's that been assigned on a personal level to support those families?
Thank you, Senator. Part of the funding that was received to support the courts was, in fact, to protect women and children, was in fact geared towards our Indigenous Family Liaison Officer program as well. We were funded for 15 Indigenous Family Liaison Officers. They do an extraordinary job. They're really very highly qualified individuals who do fundamentally two things. Firstly, as all Indigenous staff, they support any First Nations families coming through the court system, help to clarify what that system is. Understandably, there is a lot of suspicion and concern about the court system amongst First Nations communities, and the IFLOs, as we name them for short, do an extraordinary job in supporting and clarifying the system. They also support the judges, registrars and others, including in specialist Indigenous lists and including in certain circuit locations. The second area of the work that the Indigenous Family Liaison Officers do is to actually engage with community. There is a huge amount of confusion that our family law system is part of the criminal justice system when it's not. Therefore, there is concern in bringing cases to our court, thinking that perhaps children will be removed. Quite the opposite. We try and clarify through that engagement with communities that if the disputes are brought to our court early enough through our dispute resolution process and with the support of Indigenous Family Liaison Officers, we should hopefully be able to find a resolution to the dispute which maximises the chance of the child being kept in community. So that educative and engagement role is a really important part of the Indigenous Family Liaison Officer role. More broadly than that, we have a SIL program, Specialist Indigenous List program, which is rolling out in new locations all the time. Essentially, it's a program where a judge or a senior judicial registrar will head up a list which separates out First Nations matters and deals with them in a much more flexible and appropriate way, culturally sensitive way for those proceedings. They are a very significant proportion of our filings overall, our First Nations filings. They're about 1 in every 15 or so of the matters that are filed in the courts, and in some locations much higher proportions. And so our specialist Indigenous lists do a great job in being able to engage in a litigation environment in a much more culturally sensitive way. We hope to continue to grow that as much as we can over the coming period.
Thank you, Chair.
Thank you, Senator Polley. Senator Shoebridge.
Well, thanks, Registrar. Just a short series of questions. I don't know if you heard the evidence in the federal court when they were in here.
I did, Senator.
They said at one point that you were being consulted in the actions that they were taking with VIQ Solutions. Can you provide us with whatever role you had in that and what consultation happened?
Happy to, Senator. As I think I may have mentioned at previous estimates, the contract for the VIQ is coming up on 30 June this year. So there's been quite a bit of engagement with the federal court entity about whether that contract should be continued or whether there should be other processes to be undertaken. So a significant proportion of the engagement with the federal court entity has been about that. Obviously, well, in addition...
To be clear, I'm really only interested about integrity concerns and those data protection concerns.
Yes, at a fairly high level, there has been comment about the matters that were raised both at the previous Senate hearing, but also your questions on notice after that. And so because those questions were directed to our courts, we engaged directly with the federal court to facilitate those responses. So in the context of that, yes, there has been some engagement. I anticipate there'll be considerably more from here on in too.
All right. Were you consulted about the terms of the letter that went to VIQ Solutions?
Yes, briefly. I did speak with one of the officers who appeared today about that letter.
And have you had any independent information coming to you about VIQ Solutions losing staff and or the quality of the transcription services? Anything you can add since we last had an exchange on this?
No, not recently. Beyond previously, I think I may have mentioned to you, Senator, that we had real concerns about delays and problems with services, and it was in the context of those that I did engage with Court and Tribunal Services, who have been working very hard to try and fix those delays, and they have improved the situation, but we still feel that there's further to go.
All right. And finally, can you, if you don't have the numbers here, can you provide on notice, going back over the last 5 years, just what your caseload is in immigration? And can you break down it by category? There's very real concerns about just the sheer number of particularly student visa matters that are working their way through the system now, starting in Home Affairs.
Yes.
And can you include partial financial year data for this year?
I'd be happy to give that granular breakdown for you, Senator. I can indicate just off the top of my head that the last few financial years have gone from just total filings, 3,500 filings, to 4,500 filings, to 7,500 filings, and we're on track this financial year for between 10,000 to 11,000 filings. So it's an exponential growth. Beyond that, historically, the student visa percentage.
Sorry, was that student visa matters?
No, that was total filings.
Migration matters,
The student visa percentage has been historically around about the 50-55% mark, but it is really very much an indicator of what's coming out of the tribunal upstream from us.
Yeah.
At the moment, the push has been in the protection area rather than the student area, but we fully expect the student area to pick up soon.
Yeah. Well, you're like the downstream predator, aren't you? We have the Home Affairs, then we have the ART, and then we have you.
Whether you call us predator or prey, I'm not sure.
Yeah, well, however you want to describe it, but you're somewhere along that chain.
Yes.
And what's normally the delay, in your experience, if there's a surge of refusals coming out of Home Affairs, how long till that starts popping out the pipeline in your listings?
The time to finalisation has been historically very long, and hence it, in our view, has incentivised certain types of filings. But in the past has been anywhere from 3-4 years upwards to finalise a case in our system.
Yep.
Since the funding we received, the extra resources, including the extrajudicial resources, that has sped up. It's now around about the 50-month time frame and dropping, but the rate of filings coming in the front door is having a bit of an impact there as well.
All right.
Overall, our clearance rate, in other words, how quickly we can get matters out in any 12-month period, has really increased substantially from around about 60% to about 87% at the moment. So it's going in the right direction, notwithstanding that increase.
Thank you.
With indulgence, can I ask just one follow-up question?
One follow-up question, Senator Scarr.
Registrar, good to see you again. How many appellants in that jurisdiction area, migration jurisdiction area, are self-acting?
Yes, well, the rate of unrepresented litigants in migration is bang on about 80%, and 80% of those litigants require an interpreter. So it's very challenging work.
Thank you.
Thank you. That concludes the questions we have for this evening.
Thank you, Chair.
Thank you for your time.
Senators.
We'll now take a very short suspension while we welcome our next witnesses. We'll now resume broadcasting with the Office of the Commonwealth Director of Public Prosecutions. Do you have an opening statement?
Senator, just briefly, I'd just like to express the officer's gratitude to the committee for excusing the Director in light of her upcoming appearance in front of the High Court.
Very reasonable, I thought, request. We'll proceed to questions and start with Senator Blythe.
Thank you very much. I'm just going to ask some questions about resourcing of your department. Can you confirm how many current full-time prosecutors you have in the Human Exploitation and Border Protection branch?
Senator, it's not that straightforward.
Okay.
Because while we're divided into practice groups, as you've rightly corrected, and one of those is the Human Exploitation Border Protection branch, our work is done throughout our 10 offices throughout Australia.
Okay.
And particularly in the small offices, so while in our larger offices like Sydney and Melbourne and Brisbane will have dedicated human exploitation border protection branches, in our small offices such as Adelaide and Perth, that work will actually be done by lawyers who are also doing work for other branches.
Okay. Are you able to give then, I guess, and you can take this on notice if you don't have it on you, but the number of prosecutors that you have roughly dedicated to that work so that aren't sharing it in the smaller offices, and how that compares with 12 months ago?
I'd have to take that.
You could take that on. That's
take that
absolutely.
on
I don't
notice.
expect you to have that. That would be wonderful. Thank you. In terms of prosecutions that have faced delays, transfer, or compromise due to staff shortages, has that occurred for you? Given that you've just described having smaller offices where you, I guess, people are sort of sharing cross portfolios and workload. Does that result in delays in workflow?
Senator, I mean, I suppose in terms of delays, etc., we've got a KPI for ourselves of how quickly we assess a brief, and that's if it's a brief which comes to us to be assessed rather than a matter which commences by way of arrest. We've got a KPI which says that we'll assess it within 90 days.
Okay.
And in actual fact, we're meeting that KPI at the present time, so we're quite happy. I would say we did have an issue a couple of years ago when we had a very high turnover of staff.
Yep.
We had an attrition rate of around 23%.
Wow.
Before we were provided with some additional funding, and that was causing us problems. We were meeting those problems, but that was causing us problems with cases being handed from one person to another. But no, at the moment we're not really seeing problems with cases being delayed, and to a certain extent, aside from that time with briefs coming to us and us assessing them, after that, the timetabling of how a matter proceeds is very much determined by a court.
No, I understand how courts manage it, but I was just wondering whether if you had, if you've got a smaller office and you don't have someone available to attend court, say, are there delays that happen as a result of that? You're not finding that you've got any sort of shortfalls in the workforce that's causing any of that to happen? In terms of those KPIs, how do you pick the 90 days? So is that an industry standard that you're working towards, or is that just 90 days seems like a long time to assess a brief?
A lot of these matters are very complicated matters, and it does also recognise the fact that our prosecutors are doing matters in court as well as assessing those matters. So no, it's a target which us as an organisation we've set.
So you've set that. Okay. How would that compare with a private organisation? So a private
I don't think that we would be particularly comparable to any private organisation, the work which we do.
If I may, Sis further,
Yes,
Senator, Warren Day, the Executive Officer at the Commonwealth DPP. I might be cheeky enough to say that if you're in a private law firm, you've actually got probably some motivations to take a little longer with the matter, given you're charged by the hour.
I'm married to a barrister, so I'm pretty good at that.
Today! Oh, I'm just dealing with the facts of the matter. If I had a serious element to a serious answer to my slightly facetious answer,
Slightly,
Senator. Sorry to offend my friends from private law firms, Senator Scarr. We do obviously look at ourselves compared to, say, our state counterparts and the way they measure themselves and those things, and we are still stacking up and working fairly favourably. So those types of measures are things, and I know the Director takes specific interest in a range of measures about our performance to make sure we're performing well. As Mr De Crespigny said, across the board, our numbers have improved over the last 12 months compared to the year before, so we're doing quite well.
Okay. That's good. And I'm only asking these things because you guys handle the sort of worst of the worst in terms of some of the offences that people commit. So it's making sure that you've got the resourcing that you need, because that can have serious community safety implications if things don't progress as they should. So it sounds like you're satisfied with the levels of staffing that you've got so that you can meet your KPIs, and they're things that you're measuring. In terms of feedback mechanisms that exist between the CDPP and the Attorney General's Department, have any of those been triggered in the last 12 months? I'm assuming there are mechanisms that exist.
I suppose we're an independent office, as far as the attorney himself goes, herself goes, I apologise. There are things provided in the Act for discussions and interaction, but they're very formal. Otherwise, with the department itself, we have an appropriate collegiate relationship.
Senator, if I can add, we have regular mechanisms for engagement. The Director, Ray Sharp, and I talk on a regular basis. She also meets with Ms Chidgey for us to talk about issues in particular jurisdictions that might be impacting on the CDPP and its workload, but also just any general issues as to how we can support the agency and its performance.
Has anything formal in those formal processes been triggered in the last 12 months that you're aware of? No?
No, Senator.
Excellent. Thank you.
Thank you very much. That's all the questions we have for you in the room today. I imagine you'll get some on notice. But thank you very much for your time this evening.
Thank you. Good to see you, Mr. Day.
We will take a very short suspension while we welcome the members from the Administrative Review Tribunal. Thank you very much. We'll now resume broadcasting with the Administrative Review Tribunal. Mr Hawkins, have you got an opening statement?
Senator, I do not. Michael Hawkins, CEO and Principal Registrar of the Administrative Review Tribunal. I do not have an opening statement tonight, Chair, but I wonder whether you might just indulge me 15 seconds. I'd like to acknowledge the recognition afforded my Chief Lawyer during the recent Australia Day Awards, and her receipt, very richly deserved, of which we're very proud, of a PSM on Australia Day.
Hear, hear. Thank you very much, Mr Hawkins, and we pass on our congratulations as well. Thank you for that. Senator Scarr.
And hearty congratulations. I know I can sense you're feeling uncomfortable with all this acknowledgement.
Lay it on thick now, shall we?
Maybe my last appearance here, Senator.
Which just underlines how deserving you are. Humility. Registrar, good to see you again. Can I ask you, as at 30 November 2025, the ART had 126,658 cases on hand. What is your most recent update you can provide?
As at the 31st of January, our total cases on hand are now 129,444.
129,444? 44. Okay, thank you. As at 31 October 2025, you had 281.2 full-time equivalents in terms of members. What are the latest figures you've got?
As at this morning, 322 FTE of membership.
322 FTE. And as I understand it, that's against a budgeted figure of 430 FTE.
That's correct. As of today, a shortage of 108.
So today's shortage, 108 members. Okay. So what's the latest in terms of the pipeline for members who are being recruited who you're expecting to onboard over the next few months? Anything you can tell us?
Probably not for me to answer that question, Senator. I know that there are processes in place, and I would defer to my department, who might have some information.
Secretaries?
Thanks, Senator. I think if I can ask Mr Manuel, whose division is responsible for these processes, to give the latest.
Thank you for the question, Senator. The department's working to support a range of appointments to the tribunal. In December 2025, there was an exercise undertaken in merit-based recruitment process to identify suitable general member candidates as needed for appointment to the tribunal. That process is concluded. We're in the process of briefing government to support additional appointments.
Sorry, I'll just interrupt you.
Of course.
Every now and again, just to tease out some information from you. So how many additional members are you expecting that process to yield?
That process has been designed to develop a merit list from which the government can draw down to support further appointments. I'm expecting there'll be over 50 candidates on that merit list, that general member merit list.
All right, so that means even if all of those 50 were accepted, you've still got a shortfall of 58. So what's proposed after then?
The department's also recently advertised a further recruitment process that went live on the 19th of January this year, which is seeking to identify suitable deputy president and senior member candidates for future appointment.
How many senior members are there?
Typically 41 FTE. I would have to check that for you, and I will come back to you, Senator.
But I'm just trying to work out if that gives us a pathway to the hiring of an additional 108 members.
And there are additional recruitment rounds planned in a phased way throughout the coming year as well across different member types.
Okay, so do you have a target timeline to actually achieve the 430 FTE?
those processes will be used to identify candidates into merit pools, which then can be appointed to the tribunal. And the nature of those merit pools will depend on the nature of kind of applications received throughout that process.
So you're not working in terms of project management. You don't have a target date to make sure.
I haven't got that detail to hand, but I can take that on notice for you, Senator. Just in terms of the phasing of those processes.
Well, it's pretty high level, the information I'm looking for. So even if it were, for example, by 30 June this year, we expect to have 430 FTE. Do you have any sort of target like that?
Senator, we've certainly done a lot of thinking about seeking to significantly narrow the gap between what the tribunal is funded for and the number of members that are there, and the processes that have just been described are part of the plan that we set out for 2026 in order to ensure a number of appointments. I should note one of the challenges with a very big organisation like the ART is people do retire or move on, so the target constantly moves a little bit.
No, I understand that, and I'm going to ask some questions about that after I tease this issue out. But if the budgeted complement of members is 430 FTE, I would have thought that you'd have a target date to achieve 430 FTE, and if people drop off through resignations and retirements, okay, but shouldn't the target be 430 FTE as opposed to significantly closing the gap?
I think in terms of ideally where we would the position that we would like to put the tribunal in is that we have closed that gap, and that's why we have multiple processes underway.
Okay, so by 30 June 2026, you're expecting to try and close the gap by then, or are we expecting it by the end of the year, calendar year?
Senator, I very much appreciate the need for accountability in terms of aiming for targets. We haven't set a hard date because we know we're doing rolling processes throughout the year. But I would hope we did set 2026 as a year where we would really seek to drive a significant increase in the appointments. So we will be endeavouring to do that.
Okay. I'll just move on to retirements then. And Registrar, thank you for your or resignations. Thank you for the answer to question on notice SBE 25-052. I noted that there were 19 resignations or retirements in 2022-23, 29, 2023-24, 31, 2024-25. But there were also, you advised, 10 in just 2 months in July 2025 and August 2025. And in fact, based on the figures you provided, it was the first time that the complement of members had actually decreased. So it went from 351 members as at 30 June 2025 to, sorry, it went from 361 members as at 30 June 2025 to 351 members at 31 August 2025. So you actually went backwards. Do you have any well, and actually now I know you've got 322.
That's FTE. So again,
FTE,
let's not confuse our...
Okay.
Yeah.
So how many resignations have there been or retirements in September, October, November?
So just for clarity, if I can just go back to your previous question about senior members, we have 48 senior members representing 42.1 FTE.
Okay.
All right. Our 322 FTE of membership is represented by 393 members.
Okay. Yep.
Okay, so when we talk about resignations now, we're looking more at the number of members as opposed to FTE.
Yep.
So as at Let me have a look. Yeah, sorry. As of today, it's 393 members.
Yeah, so the last figure you provided in answer to the question on notice was you had 10 resignations in July and August in aggregate, 2025. So I'm interested to see, on a proportionate basis, that was more than you'd had proportionately in the previous few years. So I'm interested to see whether or not that trend continued.
Okay, so from 1st of July to 31st of December 25, we've had 18 members resign. 12 of them full-time, 6 of them sessional.
Okay.
So just in terms of percentages though, in 23-24, the number of resignations we had represented 10.9%. In 24-25, it represented 9.7%, and to date, 4.9%.
Okay. All right, thank you.
Now good time to rotate.
Yeah, sure.
Senator Scarr. Senator Polley.
Oh, thank you very much, Chair. I wanted to get an update on the latest caseload statistics, and are you in a position to answer questions about finalisation rates so far this financial year? Mr Hawkins.
Right. Yes, I have some information here. So 3 key numbers I would share with you, Senator, are the following. 46,461, 34,548 and 68,045. Now, the first number of 46,461 is the total number of finalisations we achieved last financial year. 34,548 is the number of finalisations we've achieved to the 31st of January this year. 34,548. And the other number of 68,045 is a number of finalisations we are budgeted to achieve.
So I'm very conscious of migration caseload is the most significant. How many student visa matters have been finalised so far this financial year?
So what I'd like to make, just of those last 3 comments, Senator, is that we are on track to finalise 60,000 matters this year, which is more than the Tribunal has ever achieved, and as you can see, significantly more than the 46,000 we achieved last year. So in terms of student visas, finalisations to the 31st of January, 6,373. That's for 5 months. Against 24-25, where we achieved 5,644 for the whole year.
So, sorry,
good increase.
Did you say 5 months or is it 7 months?
Sorry, 7 months. Sorry, 7 months. 5 months to go.
Yeah.
So, good figures increase there. So how many protection visa matters have been finalised this financial year?
Protection. These are the numbers we're most proud of, Senator, I have to say. So to the 31st of January, we finalised 12,823. In 24-25, we finalised across the whole financial year 17,031. And the year before that was 11,880.
11,000 the year before.
11,880, correct.
Great. Thank you for those figures.
So you'll see a significant increase in our finalisations of protection matters, and I have to attribute that to the appointment of 85 members 2 years ago, where we have significantly attacked our aged caseload. And I think we've spoken before in this place about our goal to reduce our 3-year plus caseload. And I can say that as of today, we're about 4,600 matters that are 3 years and over, and we are aiming to have those finalised by the end of this financial year.
That's really encouraging. In relation to the NDIS matters, I mean, that's a pretty heavy caseload as well. Can you give us any figures? Are they projected in the same way, I take it?
Yeah, I mean, as you're aware, no doubt, the NDIS lodgements have increased significantly. It's one of our larger caseloads that is increasing.
Can you give us an indication of, the increase there?
Sure. 23-24, we had 4,059 lodgements. In 24-25, we had 7,931 lodgements. And to 31st of January, we've had 5,037.
And finalisations?
All right, in finalisation. So for those same 3 years, we had 3,963. In 24-25, 5,039. And to the 31st of January, 3,793, which is putting us on track for about 6,800, which again, more than we've ever done in the past.
That's good, and we know how important that is so that matters are dealt with as soon as possible. But what about the protection visas? What's happening in that space?
In terms of lodgements?
Yes, and finalisations.
So finalisations we've already discussed, where we said we've done 12,823 to 31st of January. Lodgements are stabilised. We had a fair jump last year, you might recall, 24-25, we had 19,133 lodgements, 12,278 the previous year, and we're about 8,933 to the 31st of January.
I think you've already put on record that this increase has been because of the injection of new members. Is that correct?
In
Fair
finalisations?
assessment?
Yeah, it has to be. And also registrars.
Yep, that's good. Minister, just want to understand the Administrative Review Tribunal is just over a year old. Can you just explain again, because I think it's important, as to why the government decided to take this extraordinary step to abolish the former AAT, and why did the government include the merits-based appointment process? I think it's important to get that on the record. We have seen an increase there. Have you got anything to add?
Look, thanks, Senator Polly, and of course you are fully aware how important a merits review system is and how important that system has integrity and isn't undermined in any way. Unfortunately, we inherited a system where the merits review body had been swamped by about 80 political appointments. I'm sure you sat through many Senate estimates where this was traversed, and we couldn't let that carry on. Our government made a decision to draw a line in the sand and most importantly brought in a merit-based system for the appointment of new members and the candidate selection. This has been incredibly important to ensure that the body going forward in the form of the ART has public trust and confidence, particularly when it comes to reviewing government decisions. So we're working through that process of appointing new members, as the department explained to you a little bit earlier. And most importantly, we have sought to make sure that this system has the integrity that it deserves and needs for public trust and confidance.
Thanks. I am mindful of the time, but I thought it was important to get that on the record.
Thanks. Thank you, Senator Polly. Senator Shoebridge.
Thanks, Chair. And I'm sorry I didn't catch all of Senator Scarr's questions about tribunal numbers.
Absolutely piercing, as you'd expect, Senator.
Well, I'm making no judgment call on them. But can I just, there was, can you tell me the number of vacancies, full-time equivalent vacancies for tribunal members?
Yeah, so as of this morning, 322 FTE current members with a shortfall of 108.
A shortfall of 108.
Yep.
And is that meaningfully, is that shortfall, is it reducing over the last 12 months? Where was it 12 months ago?
Since January, it's reduced by 20. And whilst you're outside, the Secretary and her team gave us some insights as to the processes they're going under.
I won't go through all that again. Do you have any idea to what extent the backlog you have is explained by you being that's close to 25% below your headcount? So you have 322 is your
FTE of members, yes.
That's the current number?
Correct.
And you're funded for
430.
430.
Yeah.
So it's almost 25% shortfall. To what extent does that explain your backlog?
That's obviously having an impact on the number of finalisations we can achieve. But in saying that, Senator, I still am very proud of the achievements of our members and registrars in being able to achieve very close to our target of 68,000. We're projected to achieve about 60,000 finalisations. So notwithstanding that shortage of 108, our members and registrars have been working very diligently in achieving, as I said, close to 60,000 this financial year.
Yeah, but you shouldn't have to work at impossible rates under extraordinary pressure because you haven't got the staff that you've been funded for, should you? That's an unreasonable thing that's been put on tribunal members.
Well, I won't comment on that, but yes, I would certainly like to have those 430 members.
The budget papers also seem to show not just a significant shortfall in tribunal members, but also a shortfall in staff members. What are you funded for full-time equivalents in staff members?
So our budget was in two parts, as you're probably aware. We received half of our funding model funding in the first half, and then in MyEFO we received a second amount. So, as at our ASL for 25-26 is now 1,230. As at the 31st of December, our ASL was 914. All right, now, that's important to know because, yes, there is a difference there. But it's also important to note that as at the 30th of June 2025, our actual ASL was 899, but our budgeted ASL was 927. So we were quite close to being fully staffed as at the 30th of June 25.
Well, see, I have, and admittedly my numbers are from, I think, March of 2025, when your staffing levels were meant to be 993, but you actually only had 760.
We did. We've undertaken 112, I think it's 112 different recruitment processes since we commenced.
When you say processes, that's recruitments for one or more staff members. So do you have a plan, do you have a credible plan to get to fully staffed, I'm talking not tribunal members, but registry staff to 1,230 by the end of this financial year?
We do. And as at the, a token, well, I'm not going to say token number, but just as an example, by the end of February, we expect to have just over 100 registrars against 42 when we commenced.
All right. And can you tell me what you're funded for registrars right now and what the headcount for registrars actually is?
We don't actually have it broken down in our budget. But about 100 is where we should be.
All right. To move to another point, Registrar, you recall last estimates I asked you about accrued leave entitlements that you said weren't protected by the national employment standards and therefore weren't transferred over from for tribunal members when they transferred from the AAT to the ART.
Correct.
Have you? Are there any ongoing negotiations or any ongoing discussions with staff? With tribunal members, members, to address the grievances that many of them have about that?
There haven't been any further grievances raised with us, Senator.
Do you know what the cumulative total of hours that were accrued under the previous system but were not transferred over?
Did we not answer that in a quon?
I
know we discussed it.
I know we discussed it.
Yeah. Can you remember the quant number?
I can't, and partly it's my fault because I bounced between two different hearings earlier, and my staff had prepared an excellent set of questions here, and I'm going off a very short summary, so I'm sorry.
Look, if you like, Senator, I can take that question on notice to see whether we did actually answer it in our last round of questions on notice.
All right.
A quan about a quan.
A quan about a quan.
Yes, and in this case, it's my fault. Not.
We'll get that on
Quite often,
Hansard.
it's the other fault, the other way around. But in this case, it's my fault. All right. Thank you, Registrar. Thanks, Chair.
Thank you, Senator Shoebridge. Senator Scarr.
Thank you very much. If I can, Registrar, just ask some questions in relation to cases on hand, in particular jurisdiction matters, jurisdictions. So as at 30 November 2025, the ART had 48,826 student visa or study visa cases on hand. What's the latest figure you've got?
Did I hear you speculate last week that it might be 50,000 now? It was very good. It is 50,686.
50,686. Okay. No, I should say at that point in time it was simply speculation, and I was just looking at the upward curve. I received no information in that regard.
No, I thought you had your calculator out.
Sorry?
I thought you had your calculator out.
Protection visa cases, as at 30 November 2025, it was 39,955.
It's now 38,855.
38,855.
855.
Okay. So just did some math, which is always dangerous, but annualising that figure of the number of student visa or study visa cases that you resolved in the first 7 months of 6,373 you finalised, which is good progress. If you annualise that over the year, you're looking to annualise maybe 11,000 cases, student visa cases over the course of the year to 30 June 2025.
I'll accept your maths.
Okay. So that really is resolving less than a quarter of the study visa cases you have on hand in one complete year.
That's right. But Senator, you and your colleagues last week passed legislation that is going to give us an enormous advantage, if you like, in being able to
resolve cases on the papers.
Yep.
So that was going to be my next question. What steps do you have in place to operationalise that? I'm not sure. Is the legislation in effect yet?
It hasn't received royal assent yet, and we're still waiting for regulations from Home Affairs. So when we get those, we'll be operationalising it as quickly as possible.
Okay. Do you have plans? Are you putting aside cases that could be resolved on the papers? How are you?
We don't need to. We have more than enough.
Okay.
Yeah.
All right.
The trick for us, Senator, is making sure we have sufficient numbers of matters constituted to members so that we're not caught short with the enactment of the legislation.
Yep. Okay. Understood. Secretary, I'm going to delve into this transcript from our last estimates and read something that you said at the last estimates, which always puts the fear of whatever into people in estimates. But
I always do reread the previous transcript
do you?
in my preparation.
Do you know what I'm going to ask?
I'm not sure, but anyway, I'll...
Let's see. Page 107?
You've even bound it, Paul.
Huh? I didn't bind it.
Senator Scarr.
I didn't bind it.
No, someone else did.
Yeah. So there was a discussion in relation to, and it's been an interesting discussion actually, the perception of the ART with respect to why there are so many student visa cases being overturned or remitted back to Department of Home Affairs, the review being successful. And there was evidence from the Department of Home Affairs as to why, during the last estimates, as to why that may be the case. There was some suggestions from the Registrar and the ART why it might be the case. And we were looking for a human bridge, Secretary. And this is what my transcript says. And Senator Shoebridge actually raised this, so I should give him a shout out. So we were referring to, he gave some Cliff ambulance analogies. Ms Jones, I would say we should seek to tackle it in both ways. As I said, we do engage with Home Affairs. Listening to the detail that's just been provided there, I would like to undertake to raise it myself with Home Affairs. So have you had any discussion with Home Affairs with respect to why there's such a high rate of success in terms of these reviews? I think we determined at the last estimates that typically successful reviews were running at 25% historically, but now the review success rate's up to 44%. And you were going to have a discussion with Home Affairs just to see what was happening.
So, Senator, we have followed up on that. And I'm going to say we. I know I did specifically say I would discuss it with Home Affairs, but I did ask Ms Bogart and Mr
No, I always assume you're speaking for your department.
Royal
we.
We were in agreement that there was an issue there that could, with some good engagement with Home Affairs, potentially produce a positive outcome. So I'll just ask Ms Bogart at first instance, because she spoke directly to her counterpart.
And we've got Home Affairs on tomorrow, so I'm going to put to them what you put to me.
Yeah, okay, I'll be careful. And look, I think the policy detail is best asked of Home Affairs, but I was able to engage with my counterpart to understand some of the issues that were raised in the last hearing. I know one of the issues was around documentation and when it was received and not received, particularly enrolment certificates, for example. Home Affairs has advised that they have made changes to the processes based on those issues already. So they are requiring that at the time of the decision. And again, I will let them go into the full detail. I wouldn't want to get their policy wrong. I've also spoken to Mr Hawkins about to ensure that those changes are already being seen and has confirmed that that change that Home Affairs has made has reduced the numbers on that particular basis, on that particular type of documentation. And we do engage regularly with Home Affairs and with the ART, both separately and together. And I can confirm I know that there's some really good working relationships between the three agencies.
Some good working relationships. Which working relationships aren't good? Sorry, go on.
There are good working relationships. I know that the ART and Home Affairs are starting to organise strategic sessions to really work through some of these issues so that we can make that continuous improvement. So regular meetings. We are also attending the next session of that at the end of February. So there is an ongoing conversation to identify where there are issues that are causing blockages in the ART, and Home Affairs is actively looking to manage those where they can.
So I've got a follow-up question on that, but first to you, Registrar, are you seeing any change then? Are the members identifying any change in the types of cases coming through, the new cases, or it's too early to tell?
It is too early.
Okay, all right.
But we are aware of it.
Okay, so Ms Bogart, one of the issues I was grappling with was whether or not this phenomenon was arising because the nature and merits review undertaken by the ART is de novo. So if someone hadn't squared away an enrolment certificate, they didn't even have an enrolment certificate, right? They put in a visa application, gets knocked back. They then come along to the ART and they've got until their case is heard to get their ducks in a row to get the enrolment certificate. Is that a cause of why we've got this high remittal rate, or is it the clunkiness of the system? Can you give us more detail?
My understanding, and again, you should talk to Home Affairs about the detail, is that is precisely one of the issues. I know that there are other documentation pieces, but that enrolment certificate is one that I'm aware is happening in precisely what you have just described, that it's knocked back because it doesn't exist by the time it goes to the ART. It does exist, and so it's remitted back to the department for decision. But I understand there are other forms of documentation that may not have the same case apply to them. So best to ask Home Affairs for the detail of that. But that particular circumstance is one where Home Affairs has put some processes in place to address the enrolment certificate not being received at the time of the initial application.
And Senator, other reasons may be proficiency of English, access to funds, and by the time it comes to us, they've obviously done more courses in English, for example. They may have squared away their finances and been able to produce better evidence, just as two examples.
So the point's been made by Senator Shoebridge, and we actually had this discussion when we were debating the bill, as to whether or not this was arising because of how Home Affairs was handling the applications, or because the nature of the merits review is de novo, so you necessarily have an opportunity for an applicant to seek to present and tender into evidence new material to be considered as part of the review process de novo. Are we talking about an issue which is in the latter category or the former category?
I think it's the former.
Sorry, the former in terms of...
The processes that Home Affairs had in place, I think that's accurate in terms of them... Actually, I'm going to be careful. You're the one who's done the speaking with them. I'll let you describe.
I think the issue, and again, best to ask Home Affairs for the exact detail, is that the requirements that they had were that the application could still be made without an enrolment certificate being provided at that time. They have changed that to require that enrolment certificate now to be provided at that time, so that there can't then be the delay that they can get it again when they get to the ART.
But what's stopping someone from appealing simply because they didn't provide the enrolment certificate?
They may still appeal on other grounds, but the appeal isn't because they didn't have the enrolment certificate. It's one less thing that they are able to appeal on. I suppose that they've changed.
So, I'm very interested in the detail on this. So sorry to belabor.
And I
the
do
point.
think Home Affairs is best placed for the detail. I have a basic understanding of it, which I think is becoming clear. But what Home Affairs has explained to me is that they have rectified that particular issue in a way that now matters won't flow in the same way to the ART as they had previously been flowing. But I would suggest that the detail is best put to Home Affairs tomorrow.
Okay, I'll do that. Thank you.
Thank you, Senator Scarr. Senator Shoebridge has assured me he's got a very short 3-4 minute block.
Thank you, Chair. But the conversations are ongoing. Is that there's basically some kind of liaison between the department, AG's, Home Affairs and the ART to make sure the system works as a system.
And I think, as Ms Bogart said, there are bilateral engagements between the Tribunal and the Department of Home Affairs, but then there are trilateral, because we want to be part of it in case there's any policy or legislative change that we can contribute to.
And one of the issues that was identified was that people were filing their application for a visa without having enrolment confirmation, and then being refused because it didn't have enrolment confirmation, which was an essential element for the visa, and then it bouncing through the system. Now, you can't file unless you have enrolment.
That's right.
Confirmation, which should at least stop some of the bounce through the system.
That's right.
All right. Well, we might just sort of monitor this as it goes forward. I did find those numbers. They were given to me afterwards by someone much more competent than myself.
And I have the same situation, Senator. Someone more competent than me has given them to me.
Yeah, well, that's good. This is the way the world should work.
We shall both take them.
But the numbers are that at the close of business on 13th of October 2024, salaried members of the AAT had a total of 9,780 days of notional personal leave at an estimated cost of 10.6 million. And then when, I assume it was soon after the 13th of October, the reset was done and everyone was limited to 20 hours.
20 days.
20 days per salaried member. It was effectively halved down to 4,000, well, less than half. those personal leave entitlements were slashed down to 4,842 days at an estimated cost of $4.7 million. That was no doubt a saving for the ART, but it was a $5.9 million hit for entitlements to employees, to salaried members of the AAT. It was a $5.9 million hit to the members.
Senator, I don't look at it as a saving to the tribunal. I look at it as something that was not an entitlement, and therefore we weren't liable for it.
Well, but if people saw it on their pay slips and they saw it accumulating, and I'm sure people had taken personal leave entitlements beyond the 20 days previously, I could tell you now, if it was sitting on my pay slip, I would have seen it as an entitlement. I'm sure if it was sitting on your pay slip, you would have seen it as entitlement, and it disappeared.
It does, because I'm in the same boat. But the position was, it was very clearly notional.
Did it say notional on the pay slip?
It certainly said it in Orion, the pay system.
It said it in Orion?
In the Orion pay system.
Did it say it on the pay slips for the salaried members? Did it say, this is notional, can be subject to being cut in half at any point?
I would have to take that on notice as to what was on the pay slip.
But
it's certainly in the system that it was notional. It was certainly in all the literature that was available to members that it was notional.
All right. Well, can you provide me with the where it is that it says it's notional?
Didn't we do that in the Quan as well, Senator?
Well, the not in this Quan. I've got the leave for members guidelines.
Okay, well, back to where we were. I'll definitely take that on notice and provide it to you.
And I was told the tribunal members are stationary office holders whose terms and conditions are provided for in the ART Act, not the Fair Work Act.
Correct.
Can you provide where it was that the salaried members were advised that this wasn't an actual entitlement, it was a notional entitlement?
I will provide the literature available.
Minister, are you comfortable with salaried members of the AAT in the course of 24 hours losing 4,938 days of personal leave?
Well, Senator, we've been through this before, and I'm a little confused because we've made it clear on a number of occasions that those members are statutory office holders. And so I don't think that's the correct language to say that there was a loss of entitlement. It didn't exist in the first place. But again, I mean, I've said this before, the AAT and the current ART are independent from government, and the President's discretion is a matter for the President. But we have been through this before. There is no entitlement to that leave. They are statutory office holders, not employees.
But see, traditionally, at least, the Labor Party would have said, well, actually, taking 4,938 days of leave off a workforce with no compensation, which they thought they had because it appeared on their payslip, that's bad. Traditionally, Labor would have said, actually, we support leave and leave entitlements, and we think it's bad when the government takes more than half of them.
The government didn't take them. You are misrepresenting this.
Without any
you are
compensation.
misrepresenting what has happened on purpose to try to confuse this issue. And I've been very clear. These are statutory office holders. There was no entitlement, and the current situation has been clearly explained to members. But again, the situation that arose, it's the discretion of the President currently and under the former ART, but to try to misrepresent this as an employment entitlement is wrong.
We see what the registrar said in response to concerns raised by Professionals Australia was, and relevant to this, responding to the concern that Professionals Australia had about the loss of leave. In relation to the first issue, the analysis in your letter is flawed. As a personal carer's leave under the AAT Act, as is the case under the ART Act, is not a legal entitlement but discretionary. Any amounts of personal carer's leave that were shown on the AAT's Orion pay system were purely notional and were described as such in internal AAT documents available to AAT members dealing with their terms and conditions of appointment. I mean, what does available to members mean? Does it mean if they went and approached you and said, can you please show me the internal Orion documents, they would find them?
So, Senator, in Quan SBE 25-055, we provided to you the provisions of the AAT Guideline on Members' Terms and Conditions, August 2024, which set it out. Prior to the issue of the 2024 guideline, information on the AAT intranet made it clear that personal leave was at the discretion of the President and set out the notional personal leave arrangements. There was a document titled Notional Personal Leave Arrangements for Full-Time Members, which we attached as Attachment A, which dated back to 2020. Which made it clear that changes in arrangements for members accessing the discretionary notional personal leave balance was in the Orion system. When an AAT member applied in Orion to use their notional personal leave, a note in the online application form indicated that they were applying for a period of leave from their notional personal leave balance. And I think we provided you a screenshot.
Yes, and I've seen that. It's one thing to say, well, it's discretion as to whether or not your leave will be granted by the President, which is how I read that. It's another thing to say, well, at any point, the President's going to chop it in half. These seem very different things. The notifications you're giving seem to be addressing the fact that the President has a discretion as to whether or not to grant the leave because the needs of the tribunal and requirements and staffing of the tribunal. That's one thing. It's quite different to say, well, actually, they should have read that as saying, well, at any point, we're just going to chop your leave entitlements in half. They seem very different things to me.
I can't comment on that, Senator, because it was covered in the transitional legislation which determined which leave entitlements were carried across to the new tribunal.
All right. Another time.
Thank you, Senator Shoebridge. We're now in a position to release the Administrative Review Tribunal. Thank you for your time this evening.
We shall see you next time.
Thank you. We'll take a 1-minute suspension while we welcome our next witnesses to the table. Thank you very much. I now welcome officers from the Independent National Security Legislation Monitor. Mr Blight, would you like to make an opening statement?
In the interest of time, could I offer the 1-minute version?
I would very much appreciate the 1-minute version.
Look, I and my team are effectively a specialist law reform body that looks at Australia's national security and counter-terrorism laws. These are laws that cover some very wide-reaching offences, give police and security agencies extraordinary powers, and often operate mostly in secret. It's my role to look at how they're actually working, including by looking at classified operational information where necessary, and to consider if they're proportionate, necessary and effective, and whether they comply with Australia's international obligations, including our human rights obligations. In the 2 years that I've been Monitor, I've completed a review of the main secrecy offences in the Criminal Code and a review of certain advanced cyber surveillance warrants available to the Federal Police and Criminal Intelligence agencies. I'm in the final stages of a review of Australia's espionage, sabotage and foreign interference laws, and I'm about halfway through a review of our definition of terrorist act. Happy to take questions about any of these.
Thank you. I very much appreciate that summarised version of your opening statement. Senator Blyth.
Thank you very much, Chair, and thank you for that short version of your opening statement. I would like to ask you some questions about the last piece that you mentioned, which is looking at the definition of a terrorist act, and you mentioned that you're halfway through your review into that. Are you able to give us an update on the timeline in terms of when you foresee delivering that to the Attorney-General?
Sure, the timeline hasn't changed. The review was launched in August 2024, and I expect to deliver the report to the Attorney in August or early September this year.
Okay.
It was launched in 2025 and it will be delivered to her in 2026.
Fantastic. Yes, I was going to say
it
was only last year.
Sorry.
I know it's too late to be saying Happy New Year to people still, isn't it? Given that a significant portion of Australia's terrorism threat is driven by radical Islamic extremism, obviously there has been commentary around whether religion should be removed as a motivating factor within the Terrorist Act. What has been, I guess, what you've been collecting from stakeholders?
There's a bit to unpack in that question. I guess the first thing is to remember that the Director-General of Security has been very clear in his 2025 threat assessment that more than half of ASIO's caseload is not Islamic State driven. So there is also this other 50% of their workload roughly that is other types of ideologies. So there is absolutely a serious and continuing threat from Islamic State inspired attacks, but there is also another 50% of their caseload.
Is it fair to say, though, that those Islamic State-inspired attacks are what has affected Australians? So that's the 15 innocent people that died in Bondi, that's the Bali bombings, I think.
Absolutely. Look, the terrible attacks in Bondi and other attacks inspired by Islamic State have been the vast majority of terrorism prosecutions in Australia. And I've done some analysis of the prosecutions, and in fact, the only time we've had prosecutions of non-Islamic State has been in the last 5 years. So this is prosecutions actors driven by what is sometimes described as extreme right-wing or right-wing nationalist ideology. And my review is really thinking about the future of terrorism and whether our definition is fit for the future. There's no question that Islamic State-inspired terrorism and the kinds of terrible attacks that seek to advance that cause are at the very centre of the definition. Nothing in my review, none of the submissions I've had suggests that should change. But the edges are changing, and in the last 5 years, this increasing number of extreme right-wing cases starting to come through. It's by no means the 50% that ASIO is seeing, but we're not seeing as much success in the prosecutions of those cases. So only around 7% over the last 25 years have been these right-wing and other extremist cases. But in the last 5 years, we've had 21 ISIL-inspired people who've been prosecuted and sentenced, and 4 right-wing extremists or white supremacists. So that's about a bit under 20% of the convictions in the last 5 years. But if you look at the acquittals, it's the other way round. 2 Islamic State-inspired actors have been acquitted and 3 right-wing or white supremacists, so about 60% of the acquittals. So there's something going on in these cases that they're not working out as well. So the success rate in prosecutions drops from something like 86% to 57%. And so my review is really around this emerging area, and is the definition fit for the purpose for the future? It's not so much is there anything wrong with the centre of the definition.
Are you also gathering feedback then on the potential consequences of removing religion as a motive in the terrorism definition?
It's not quite so accurate to say removing religion as a motive. There are 3 causes. So for something to be terrorism, it needs to be a terrible violent act, it needs to be to coerce a government or the population, and it needs to be to advance a political, ideological or religious cause. And there's a real question as to whether there's any difference between a religious and ideological cause. Most of the cases in the sentencing, judges talk about religious ideologies. So there's no question that the ISIL-inspired type attacks would always be in the definition of terrorism. There are questions about whether the word religion is doing any different work to the word ideology. And I'm thinking about that in the context of whether the word ideology needs a definition that lets us scaffold a sort of neutral approach to terrorism that looks equally at emerging types of terrorism while retaining, without any doubt, that those who would commit terrible violence to advance the ISIL cause would clearly remain inside the definition of terrorism.
Okay, and I guess I would go that even your own research has indicated that 95% of terrorism cases has found, and of 83, so it's a larger number, involved religion as at least one of the motives.
Yeah,
so should this even be debatable, whether religion and ideology should be interchanged? Do you think that that's, given your own research is saying 95%?
Up until 5 years ago, it was 100% of cases were Al-Qaeda or ISIL or one of those type of organisations. What I'm trying to do is think about how are courts grappling with what does ideology mean? And this is an area where there seems to be a lot of uncertainty. I've done a lot of consultations in this review, and I've spent time, for example, with dozens of sociologists who've given me hundreds of definitions of the term ideology. And that kind of uncertainty just doesn't work for courts. And I think that's one of the reasons we're struggling with police and prosecutors bringing these fringe cases. So I'm thinking about how do we define ideology clearly? If we do that, a consequence is that the word religion may be redundant. A redundant word isn't necessarily a terrible thing in a law, but then there's a legal policy question of, are there any harms from retaining a redundant limb? So that's sort of the line of thinking, but the first step is, what does ideology mean? What do we need it to mean for the future of terrorism?
And I guess this started pre-Bondi, so biggest terrorist attack that we've had on our own shores. 15 innocent people died. Would you consider that an act of religiously motivated terrorism?
Look, obviously I can't comment on a case that's currently being prosecuted, but if we take that class of cases, someone acting to advance a cause like ISIL, committing an act that clearly, in a devastating way, harms Australians and clearly intimidates a section of the population, that is a central, nothing falls more centrally into our definition of terrorism. The actual case matter for the courts, but that style of thing, no one's raised any questions in my review that shouldn't remain at the very centre of our definition of terrorism.
Okay, that's fine. Thank you.
Thank you, Senator Blythe. Senator Shoebridge.
Thanks, Chair. And look, thank you for doing the work, and thank you for sort of applying an inquiring mind as to where the definition should sit, given the emerging trends we're seeing. The WA Police indicated in relation to the incident the attempted mass casualty bombing event in Perth on Buru of a First Nations rally, that the ideology behind that was sort of white male power. And then the AFP, just in questions last week, when I was asking about the issue about white male power and the extent to which it relates to reportable concerns about terrorism that they have, indicated that it was over a third of the matters that were before them for their investigation related to some concept of white male power or racist nationalism. What, if any, data are you getting in your review about the extent to which that ethno-racist white male power ideology is part of the landscape here?
There's quite a bit of this in the issues paper we released for the report, and I've relied mostly on ASIO because what I'm trying to do is look ahead 10, 20 years. And so I'm looking at the intelligence material, which ASIO summarises in their public threat assessments, And Mr Burgess gives a very clear picture that whilst Islamic State-inspired terrorism remains a serious problem, the nature of terrorism in Australia now has this whole other aspect. Over 50% of the cases, which he describes as white or nationalist or racist ideologies, and many involving a mixture of ideologies, is quite difficult. It's also worth noting that almost in his 2024-25 assessment, he said in almost all cases, the suspects were minors and were individuals previously unknown to ASIO, and that they were almost all Australian-born and self-radicalised. Now, that's quite a different profile to the Bali bombers, to the kind of al-Qaeda terrorism we had in 2002 when this definition was enacted into law. I'm not saying there's anything wrong with how the definitions operated in the past. I'm trying to forecast the future, because this definition hasn't changed in a quarter of a century. Terrorism's changed a lot in that time. And the definition is difficult to change. Hundreds of laws depend on it, so it's a very sort of careful review. But to answer your question, mostly I'm relying on ASIO's statements about what they're seeing as the future of terrorism, and the AFP statistics you've just provided are consistent with that approach.
All right. You looked at the sunset provision for for the detention powers under Division 3 of, I'm trying to remember the name.
That wasn't me, I'm afraid. You might be thinking about the post-sentence orders that my predecessor reviewed.
Yes. Well,
I didn't do that review, so
your predecessor in the office did the Insulum. Sorry, the Insulum did it. There's legislation now before the Parliament to extend the sunset again. I think this might be the
ASIO questioning apprehension powers.
Yes, indeed. I think this might be the 6th extension of the sunset. The sun never sets on these powers. What was the Insulum's position on those powers and the recommendation in relation to sunset?
I'm trying to recall, because actually that wouldn't have been Mr Donaldson, it must have been an earlier Insulum. Generally, my office reviews laws at the request of the PJCIS, so they're often put into the Insulum Act as a mandatory review, or they're referred by the committee with limited scope for own motion. So I can't actually recall when that one was reviewed. I'm sorry, I'd have to take that on notice.
All right. But do you have a position on the current proposal, which is in the Australian Security Intelligence Organisation Amendment Bill number 1, 2025, and Australian Security Intelligence Organisation Amendment Bill number 2, 2025, which both seek to extend the sunset provisions, I think, until March 2027?
That isn't something I've reviewed, and my role is to look at laws that are in operation rather than bills that are before the Parliament.
Well, of course, what this is seeking to do is keep in operation the powers that ASIO has to continue to access Division 3 powers, which are the detention and questioning powers, under the ASIO Act.
I do understand, and I do recognise that there are literally hundreds and hundreds of national security laws, and I'd love to be able to review them all. But with the time and resources I have, I've focused on the 4 reviews that I've mentioned.
Yeah, and just so the record is correct, up until this bill, which the sunset provisions have been extended 5 times since they were originally introduced in 2003, so this will be the 6th time. But you haven't formed a view about whether or not sunset provisions like that never set have any efficacy?
When I prioritise my work, I give the highest priority to reviews that are mandatory under my Act, and the reviews that I've undertaken of the secrecy offences, of the surveillance laws, of the espionage, foreign interference and sabotage laws were all mandatory reviews that were overdue when I commenced the role, so I prioritised my resources into those mandatory reviews. The only own motion review I've commenced is the definition of terrorism, which I took on as a priority given the passage of time, the significance of those laws and their effect on many other laws, and the change in the threat of terrorism.
Well, it's quite a side project, the definition of terrorism, Mr Blight. But do you have adequate resources, you think, to deal with the scale of the duties that are sitting in front of you as the Insulum?
Well, I am very lucky to be the first full-time Insulum, and in fact, just before I commenced, the office received a financial injection in the 2023-2024 budget and went from being a part-time monitor with a couple of administrative secretariat staff, and I'm funded as a full-time monitor, and with some reallocation of resources, I now have 6 in-house lawyers who are doing those 2 reviews. So I think with the resources I have, we're covering quite a lot of Australia's national security laws, but the Parliament certainly does pass a lot of national security laws.
Yeah, all right. Thanks. Thanks, Mr. Blake.
Thank you, Senator Shoebridge. That's all the questions we have for you this evening.
Thank you.
Thank you very much for your time. We'll take a very brief suspension. We welcome our next witnesses. Thank you very much. We now resume with officers from the Office of the Inspector General of Intelligence and Security. I'd also like to especially welcome Mr. Paul Cronin, who has recently commenced his term as the Inspector General of Intelligence and Security. Inspector General, would you like to make an opening statement?
Not an opening statement as such, Chair. Paul Cronin, Acting Inspector General. I just simply wanted to, and you beat me to the punch somewhat, the Honourable Chris Jessup, KC, concluded his term as Inspector General last Saturday, the 7th of February. A new Inspector General of Security has not yet been announced, and in accordance with our standing acting arrangements, I will fill that role until a new Inspector General has been announced. Thank you.
Thank you.
If I may.
Sure.
I also, just on behalf of the government, want to wish to acknowledge the contributions of Dr. Christopher Jessup, who concluded his term as the Inspector General of Intelligence and Security on the 7th of February. During his time, Dr. Jessup was known for his deep legal expertise, diligence and commitment to ensuring agencies in his jurisdiction operated with legality and propriety. Dr. Jessup ably led the Office of IGIS through the most dynamic national security environment we have faced in decades, which has seen changes to the oversight mandate of IGIS and a significant expansion in the capabilities of the national intelligence community. I want to thank Dr. Jessup for his service and significant contribution to the Australian community. Thanks, Chair.
Thank you, Minister. We'll proceed to questions and go to Senator Shoebridge.
Thanks, Chair. Well, I just wanted to extend my gratitude too, for the record. I thought Dr. Jessup's engagement with the committee, the work that he did, was incredibly important. And for the record, we've appreciated the responses that he's given to the committee. Chair, I've just got a small technical difficulty here. Do any other members have questions? Well, I'm at a disadvantage here with my questions. I'm terribly sorry. I've lost access to my Google Doc.
Google Doc's not opening?
It's not.
Is this a...
These things happen.
I thought these questions all emanated from your group.
Well, no one ever thought that, but for the record, they were necessary to, and I've lost internet connectivity with that Google Doc.
It's not a conspiracy.
So I may have to put the questions on notice, and I apologise for that.
Well, thank you for your efficiency there, Senator Shoebridge.
Yes.
And thank you very much for your time and for hanging around until this hour.
And Mr. Cronin, as an acting, in your acting role, that was a nice, simple way through estimates. So, I don't know how you managed to do that, to knock off the access, but it was very effective. This is the security agencies at work.
Thank you very much. You should definitely run while you can. You've been released. Thank you very much. We'll take a very short suspension while we welcome our next witnesses. Thank you. I now welcome officers from the Office of the Special Investigator. Director General, would you like to make an opening statement?
If I may, Chair, it's been a while, so if I could, just very brief, maybe 2-minute update summarising some things we can put on the record. I just want to note, first of all, that the joint investigation with the AFP, Operation Emerald as we call it, continues to make significant progress. We're working to complete the joint investigations as expeditiously as possible, cognizant of the potential impact on the welfare of those involved and the broader defence community. Operation Emerald has in total commenced 53 investigations involving allegations of war crimes by Australian Defence Force members in Afghanistan. To date, our investigations have resulted in one former Australian soldier being charged with one count of war crime murder, and that's now before the New South Wales Supreme Court. We currently have 13 active investigations, and a further 39 investigations are no longer subject to active investigations, subject to any new evidence emerging, of course. Our preparations of briefs for the Commonwealth DPP continue to be carefully and managed and quite resource intensive and require the support of key stakeholders. I would also just like, in concluding, to mention and advise the committee of the retirement of the Honourable Margaret Weinberg, AC, KC, and acknowledge his contribution to our work as a former judge of the Federal Court and the Victorian Court of Appeal, as well as a former DPP and a Dean of the Faculty of the Law at Melbourne University. Mr Weinberg's extensive experience has been invaluable in guiding the challenging work of the OSI. Given the advanced stage of our investigations, we will conclude our operations with existing experienced legal staff, including senior counsel who have worked very closely with Mr Weinberg in providing advice to the investigations and working with the AFP leadership under our joint investigation model. Thank you. That was under 2 minutes.
Thank you very much for working through that opening statement very efficiently, and I also know that you provided that to the committee ahead of time, and the committee will table your opening statement. We'll proceed to questions and go to Senator Shoebridge.
Thanks, Chair. Thanks for your attendance today. So the OSI commenced operation, was it in January 2021?
Yes.
And so this makes, you've now been operating for over 5 years?
5 years.
What's your budget this year?
This financial year, it's about $47 million.
All right, and what was it last year?
Something like that, 48 million.
And if we went back, it's consistently in the order of that?
Yes.
And so far, with $250 million, you've successfully commenced one criminal prosecution with a $250 million budget.
There's been one charge and that's pending. It'll go to the Supreme Court in 2027.
I beg your pardon?
Proceedings will commence in early 2027 for that case.
So you've commenced one prosecution.
The DPP has commenced one prosecution.
All right. As a result of your work,
yes,
the DPP has commenced one prosecution, and that's what the Australian public have to. As a result of $250 million of funding that's gone to your office. That's the takeaway metric, isn't it?
No, the takeaway metric, Senator, is this. We commenced in 2021. We set up an agency from scratch, and we've investigated 53 matters 39 of those have been finalised to the best of our efforts and are subject to no further investigation unless something else emerges. And we have 13 matters which are actively under consideration, and we're actually preparing and finalising briefs of evidence for consideration by the DPP and ultimately by the for the consent of the Attorney-General. That's not an insignificant amount of work done in that period.
How many people are the subject of those investigations? 39 that have concluded.
I won't comment on the numbers because
let me finish the question.
Okay.
How many of the people the subject of those 39 investigations which have concluded without prosecution, how many of them have left the jurisdiction and that was the reason why the prosecution didn't proceed?
That is not, I can't go into the details, but that is not a factor in our decisions to pursue matters.
How many? Are there 53 individuals?
No.
How many individuals?
This is over a period of about 10 years, and I can't give you the exact number of individuals involved because it's a large number, and I'd have to take that on notice and give you a number if you like.
Well, indeed, is it more than 53 or less than 53?
Oh, more than 53.
And so far, one individual has been prosecuted as a result of
has been charged.
What ongoing communication does your office have with the Inspector General of the ADF?
We have a process in place since the beginning of our work whereby we have a formal process of requesting information to the IGADF. So we have a single channel for communicating because of, I won't go into the details, but because of the nature of that inquiry, we cannot access things directly from them. We formally write to them through an RFI process, a request for information, a letter from us, usually from me in person, and responded by the IGDF to me. So that's our channel of communication, and that's the only channel. So we have a clear record of what information passes between us.
How many times since 1 July 2023 have you accessed that RFI with you?
Oh, it's an ongoing process, Senator. We've been requesting information from the IGADF since February, April 21, so it continues. We make requests for information to the IGADF, not on a regular basis, but on an ongoing basis.
Yes, so...
If I may, can I just complete my answer, just for the sake of completeness? As I said, our investigations are now at a later stage because we've pretty much in the process of preparing briefs. The tempo of RFIs has declined, but I do not preclude further RFIs going to the IGADF. So it's an ongoing process of RFI.
I'm passing no value judgment on
sure.
numbers.
Just wanted to clarify that.
To get a sense of the number of RFIs that you have made to the IGADF, and I don't want you to go back forever, but from 1 July 2023.
23, I couldn't tell you from that date. I could take that on notice, but I would say, just based on first principles, that most of our RFIs would have preceded that time, but I wouldn't want to stick to that point. I'll take it on notice from... Yeah. I'll give you the number of RFIs since July 2023 to the IGADF. Yep, I'll provide that for you.
Your engagement is with the IGADF.
That's right. As I said, we have a formal protocol whereby we communicate through correspondence with the IGADF.
With Mr. Gaynor.
Mr. Gaynor, Mr. Jim Gaynor is the recipient of my correspondence, and I'm the recipient of his correspondence.
Do you know if any of the information that's come from the IGADF since 1 July 2023 has come from a former assistant IGADF, Major General Brereton?
I would have to take that on notice. There have been quite a few, so I haven't paid attention to the annexes of what's been provided and what the source was, but right. I can do that for you if you like.
I'd appreciate that. And
it's usually documented. There's a lot of reports and stuff like that we need to have cleared, and so I wouldn't be able to tell you off the top of my head.
I wouldn't expect you to tell me off the top of your head, Mr. Moriartis. But if you could provide that on notice,
we'll do that.
And the dates upon which that had happened, I'd appreciate that.
Yes.
Can you indicate are there any briefs that have been provided to the DPP that are sitting with the DPP awaiting their decision?
We are working very closely with the DPP. We meet regularly with them, and it's an iterative process. We've had briefs with the DPP that have been considered, that have not been proceeded to prosecution, but that's historical. There are ongoing engagements with the DPP preparing briefs of evidence as we speak.
How many briefs have you presented to the DPP that as a result of, I assume, the position of the DPP, there's been a decision not to prosecute?
Could I take that on notice again? I have to recollect. I can't recollect the number, but it's not a large number, but I want to be accurate. I'd like to be accurate. And when I say briefs of evidence, there could also be various forms of requests to the DPP about things. We could take that on notice.
All right.
And I'll provide you with a figure.
And if you could, how many briefs are currently with the DPP awaiting a decision by the DPP?
Can do that.
All right. They're my questions, Chair.
Excellent. Thank you for your efficiency, Senator Shoebridge. That concludes the questions that we have for you this evening. So thank you very much for your time. That means we are now in a position to conclude today's proceedings. But before I do, the Secretary has provided her opening statement, which the committee tables. Thank you very much for providing that. And also, with indulgence, wish a fellow committee member, Senator Polly, a happy birthday for today.
What better way to spend it?
What better way to spend it than finishing 8 minutes early for today? I thank ministers and witnesses for their attendance, as well as Hansard Broadcasting and the Secretariat for all of their assistance throughout the day. I'll get Senator Blythe to move that we accept any tabled documents throughout today. Thank you very much. And I'll also remind senators that written questions on notice should be lodged with the Secretariat by 5 p.m. Friday the 10th of April 2026. This hearing is adjourned.